Wait, please. Back to mention item number 31. Here, my lord, we are trying to solve the matter amicably, my lord, outside the court.
You inform the other side?
Yes, I have informed Mr.
Sir
Tap.
D. Panging, learned counsel for the petitioner with concern from the other side, as for listening the matter after
Can it be on 3rd? In the meantime, if it is not done, we
3rd
have
of April.
3rd of April.
Fair.
3rd of April is holiday, Lordship.
Oh, my lord, 4th then, man.
4th is Saturday.
Fourth is-
Oh, sorry. Next day, Monday thereafter, man.
6.
Man.
Okay.
Obla, highly obla.
May I plead, Your Lordship? My lord, I beg to mention item number 14, my lord. Yeah, my, this matter may be taken up tomorrow, my lord.
Tomorrow,
Yes, my lord. I've taken consent, my lord.
on the prayer being made by Ms. Wangmo, learned government advocate, with consent from the other side, the matter stands adjourned to be listed tomorrow.
Yes, my lord.
Tomorrow, there is a DB.
Yes, Lordship.
Can it be on Friday?
My lord, if it can be taken up tomorrow, I'll be out of station for a long time after that. After
Okay.
tomorrow.
Tomorrow.
From day after tomorrow, I'll be out of station for a long time. And our matter needs early
We'll
disposal.
try.
Yes, my lord.
Okay.
Oblige.
Lordship, I would like to mention item number 9. No, I've taken the consent, Your Lordship. May I kindly take up this matter on 30th of this month, Your Lordship?
30,
30, yes.
0. On the prayer being made by Ms. So learned government advocate for the state respondent with consent from the other side. Press for listing the matter on 30th.
Lordship.
Lordship, there's an interim.
Interim order pass earlier self.
Your Lordship, item number 28 also, Your Lordship. May I kindly take up this matter after 3 weeks?
20,
28.
Ms. So learned counsel.
Lordship, in this matter, pleadings are complete, Lordship. This matter may be listed in admission column, Lordship.
Admission column. Ms. So learned counsel on the learned government advocate for the state respondent with consent from the other side. Press for listing the matter after
3 weeks, Lordship.
3 weeks. The
Lordship.
counsel for the petitioner, however, pointed out that in this matter, pleadings have already been completed, and as such, the matter may be listed in the column of admission hearing.
Lordship, I'm for the private respondent, Lordship. Private respondent,
Okay, not for the petition.
not for the petitioner.
Okay. Your name, please?
Yasmin Gao, Lordship.
Okay.
And Lordship, my name may be reflected in the cause list, Lordship.
Okay. The learned counsel for the respondent number
5, 6, 7, and 8,
5,
Lordship.
6, 7, and 8 also submits that her name has not been reflected in the cause list. Accordingly, it is provided that the register shall reflect the name of the learned counsel in the cause list.
Lordship, I would like to mention item number 12 on behalf of Senior Government Advocate Estapin, Your Lordship. He has some personal difficulties, Your Lordship. Lordship, may kindly fix this matter on 30th of this month, Your Lordship. Item 12.
My lord, in fact, this matter has some urgency, my lord. Therefore, it was mentioned, my lord.
Your Lordship, he has mentioned this matter without taking consent, Your Lordship.
My lord, the problem is that, my lord, since there is no specific this interim order, my lord, although it was passed in this 27th 6, 2025, that the construction would be subject to the outcome of the writ petition. But it has been informed to me that, my lord, the department is carrying out, my lord, activities over the land, my lord. Otherwise, my lord, this matter, in fact, my lord, it is admitted fact that the land in question has not been acquired, my lord. The document, my lord, which I have obtained from RTI, it clearly shows, my lord, and there was some meeting with the administration,
No, Mr. Kamdog, see, I am ready to hear the matter.
my lord.
But if the parties are not ready, what to do?
On 30th, Your Lordship.
My lord,
for
in that case,
disposal.
may I pray that, my lord, this interim order passed on, my lord, 27/6/2025 may be modified. Because, my lord, despite the interim order, my lord, passed on that day, my lord, saying that, my lord, any construction would be subject to outcome of the writ petition. Still then, my lord, they are, they said, carrying out some activities over the land.
Subject to
So
outcome of this writ petition.
It is already
means,
there, Your Lordship.
there is no stay.
Yes.
there is no
There
stay.
is no-
So therefore,
So, they can go on with the construction work.
my lord, that is why, my lord,
Hmm.
this matter has some urgency, my lord.
The risks.
Therefore, my lord, if at all, my lord, this matter is to be adjourned, my lord, the interim order passed may be modified, my lord. Saying that, my lord.
How can that be, Lordship, possible without filing any application for modification, Your Lordship?
Aye, then.
My lord,
You file an IA, we will consider the same.
On 30th, Your Lordship,
38th.
30th of this month.
30, I have problem, my lord.
Then,
Then after
I-
2, Your
I
Lordship.
was requesting my friend to get the matter fixed. They said tomorrow, day after tomorrow, but she has.
Your Lordship
difficulty.
is coming back on 28, Your Lordship. So 28 is Saturday, Your Lordship. So
My lord-
30th, Monday, Your Lordship.
My lord, this sort of, my lord, this submission, my lord, it is very unfortunate, my lord, because, my lord, there are so many government advocates.
yes,
In-
That
in the-
is true.
represent the government.
Yes, my lord.
Yes, but this
If-
matter
if
is
they have not
handled
read the-
by, Your
read
Lordship,
the
from
brief,
the beginning, Your Lordship.
If my
submission is
friend has not read the
okay, Your
brief,
Lordship.
my lord, let him give some 1 or 2 days, my lord. After that, later matter may be fixed, my lord. We cannot, my lord.
Your Lordship, on
only
30th,
excuse-
Your Lordship, for
only
final
excuse the
disposal
go-
of this
the
matter, Your Lordship. And you were,
Government level who is dealing with the file, my lord. He's absent, so matter cannot be taken up. All this sort of, my lord, submission, my lord. It hampers the interest of the litigant, my lord. So, my lord, may I pray that this matter may be fixed after 2 days, my lord. So that my pride
Okay, on next Monday.
next month, my lord.
Next Monday. Recess will list the matter on next Monday. Okay.
Oblige.
Your Lordship.
My lordship, please. Lordship, I would like to mention for unlisted matter. Since yesterday I filed the petition, but there is one clerical mistake, error. So today it is rectified because urgency, lordship.
What kind of urgency?
This is a GST default. So day by day penalty is increasing. So matter may be taken up last item, lordship.
Not today, tomorrow,
Tomorrow, lordship, there is a DB. So
in the
Yes.
second half.
okay, lordship.
Second half.
Obliged.
May I
For-
please, Lordship? I
Lordship,
beg
for
to,
tomorrow, today, for tomorrow.
Yes,
I beg to mention item number 10, Your Lordship.
item number,
10. 10. Leading official is out of station, Your Lordship.
you are for the respondent,
Petitioner, Your Lordship.
petitioner. Mr. Your name, please?
M. Taso, I am appearing on behalf of R. Soike. My name is not Your Lordship.
Your name, please?
M. Taso,
Learned counsel appearing on behalf of Mr.
R. Soike.
Arsoikia, learned conducting counsel for the petitioner. You inform the other side
Yes, Your Lordship.
with consent from the other side, press for listing the matter
2 weeks, Your Lordship.
after 2 weeks.
But there is an interim order, Your Lordship.
Interim order pass early shall continue.
Obliged.
Your Lordship, I'd like to mention item number 22. I'm here on behalf of B. Picha.
Item 22.
Yeah. Kindly the matter be adjourned for 1 week, after 1 week.
1 day,
1 week.
1 week.
Yeah.
Miss, your name, please?
Yeah, big.
Learned counsel appearing on behalf of
B. Picha.
B Pizza.
Yeah.
Isha, learned standing counsel for the RT.
Yes.
You inform the other side?
Yes.
With
Lordship.
consent from the other side, press for listing the matter after 1 week. Pair allowed. This is a list the matter after 1 week.
Your Lordship, I'd also like to mention item number 23. For the same reasons that the council is out of station and the matter be fixed after 1 week.
Ms. So learned counsel appearing on behalf of Mr. Binter Pisa, learned conducting counsel for the petitioner. With consent from the other side, press for listing the matter after
1 week.
1 week, as Mr. Pisa is out of
Station, Your Lordship.
Pair allowed. This is a list the matter after a week.
Much obliged, Your Lordship.
May I please, Lordship? Lordship, I beg to mention item number 24. Item number 24.
24.
Yes, Lordship. We're praying for adjournment for 1 week, Lordship, and we have also taken consent from the other parties, the respondents.
Your name, please?
Eddie Payeng, E. Payeng.
Mr. E. Paying, learned counsel for the petitioner with consent from the other side, place for listing the matter after a week.
Lordship, in this case, I'm appearing for the respondent number 3. Respondent number 3.
Miss, your name, please.
Dirilong, Dusurilong,
Learned counsel. Enter the appearance for the respondent number 3.
3.
Respondent number 3. Any objection?
No, and next date we'll be filing Vakalatnama.
Okay. And she also submits that she will be filing her Kalanama by next day. Shall list the matter after 1 week.
One week, Lordship.
Master.
Lordship, similar prayer in item number 29 as well, Lordship. 29. We have taken consent from the respondents too, Lordship. So we are praying for adjournment for 1 week.
You are appearing for
Petitioner.
Mr. So-and-so, learned counsel for the, your name is not there? Or
E.
your-
Paying, it's there, yes.
Your name is there, yes. Learned counsel for the petitioner with consent from the other side, press for listing the matter after
1 week.
1 week.
Lordship, there is an interim. Interim may continue.
Interim order pass earlier shall continue.
Deeply obliged.
May I please also, I beg to mention item number 8, Your Lordship. I'm for the respondent.
Item number?
8. Can this matter be set up to 2 weeks?
Mr.
M. Tasso, my name is not there. M. Tasso.
Learned counsel appearing for the respondent.
Respondent number 6, private respondent.
Respondent number 6
Yes, Your Lordship.
with consent from the other side.
Yes,
Press for listing the matter after
2 weeks.
2 weeks. After 2 weeks. Parallel.
Item number 1.
Yes.
Your Honor, petitioner is a laboratory assistant working in the Department of Health and Service, Government of Arunachal Pradesh, Your Honor. Respondent petitioner are aggrieved members, Your Honor, and pursue the remedy and for their behalf by filing representation before the respondent authorities on a repeated occasion, and hence the present writ petition is maintainable in law, and respondent authority may not be allowed to raise any technical question as to the maintainable of writ petition in the present court. Petitioner in the present case is invoking the extraordinary jurisdiction of the Honorable Court, being aggrieved by denial of promotion in the service of post of laboratory technician in the Department of Health and Service, Government of Arunachal Pradesh.
Presently they are serving as laboratory assistant.
Your Honor. Initially, they were appointed on sanction post laboratory technician on contractual basis, Your Honor.
Laboratory technician.
Technician on sanction post, Your Honor.
Presently they are working as laboratory
Assistant, Your Honor.
They want promotion to the post of laboratory technician.
Technician, Your Honor.
So laboratory technician is the higher post.
Higher vacancy post, Your Honor.
So where is the document to show that it is that some of the individuals having similar qualification have already been promoted to the post of laboratory technician?
Similar. Your Honor, it is written in legal notice reply.
Is it part of the record?
Yes, Your Honor, part of the record, Your Honor.
Where? Page number?
Page number. Your Honor, page number kindly 138.
138. Yes, Mr.
My lord,
Raghav?
my lord, this petitioner, my lord,
Mm.
initially they were appointed as a lab technician, my lord,
Mm.
under the NRHA, my lord. It's a society, my lord, not a regular department, under the regular department.
Okay.
And some of them were appointed under the AIDS Control Society, my lord,
Mm.
not under regular department. They were appointed on contractual basis, my lord. For the first time for 1 year, and thereafter the service has been extended from time to time under the contractual scheme only. And subsequently, my lord, the government has taken policy decision that those contractual serving requisite length of service can be regularized by relaxing RR, my lord. And that exercise was carried out. And while carrying out this exercise, it was found that as per RR, my lord, it has to be done RR, my lord, certain qualification, my lord. But this 247 working contractual staff were there. Under this laboratory technician, my lord, laboratory technician. And out of this, my lord, only few of them were having requisite qualification as per RR, my lord. And they cannot be appointed as a technician, my lord, laboratory technician. And therefore, only 27 out of 247, only 27 were eligible. And they have been regularized to the post of lab technician under the in the regular Department of Health and Family Welfare, and well, rest of 220, they were appointed, regularized under lab technician, assistant lab technician, and their pay is, the first their appointment as per the under the contractual, they were getting 6,000, or some of them were time to time 6,000, 6,500. Now the present, the lab technician, lab assistant, they are getting far more higher than that of the amount, and they are not eligible. This in the 38th, it will clear, It's a reply to the legal notice served by the petitioner, 138, 138. Norms for appointment as they were follows, That is the reply to the legal notice, The recruitment of lab assistant candidate who have passed class 10 with the certificate, this lab assistant, were appointed. This is 100%, the recruitment as per recruitment 1988. Now coming to lab technician, Now this is the present post, which they are asking for, Lab technician, B, its recruitment is 1999 as follows: 50% by direct recruitment and 50% by serving laboratory assistant as Regular shown to 10 years, my lord, for regular. For the one must serve in the lab assistant for 10 years in the regular department, my lord.
For being promoted to laboratory technician.
Assist technician, my lord. 10 years, my lord. In the department, my lord.
Let notice go.
Yes, my lord, in that notice,
File your
my lord.
heard, Mr.
Cease income.
Cease income, learned counsel for the petitioner. Mr. Tagum, learned standing counsel for the
Health and family
department,
welfare.
being respondent number
2, my lord, sorry.
respondent number 2,
Hmm.
and Mr. One. Only one.
Only one.
Respondent number 1. This petition under Article 226 of the Constitution of India, the petitioners. How many petitioners are there?
Your Honor, 48.
48 petitioners have right for issuing direction to the respondent authorities to constitute a review DPC for considering their case
Yes, Your
for providing service seniority to the post of laboratory technician strictly in accordance with the recruitment rule 1999. Is it in force now, 1999?
My lord, as per record, my lord, this has been superseded recently, my lord, 2024. The new recruitment rule has come, but it's not on record, my lord. In the legal notice, it's just reply, my lord. The new rule has come into force, my lord, 2024.
No.
And also for declaration that the continuous service rendered by the petitioners as contractual laboratory assistant be recognized for the purpose of service benefit and promotional consideration. And also to direct the respondent authorities to commend a review DPC for granting promotion, stroke regularization, stroke seniority benefit to the petitioners. And also to consider, also direct the respondent authorities to consider their case on parity with similarly situated batchmates who have already been promoted. The learned counsel for the petitioner submits that the petitioners herein are aggrieved for denying promotion to the post of technical assistant from the post of laboratory assistant. No, laboratory technician. To the post of laboratory technician from the post of laboratory assistant. Though similarly situated individuals who are promoted to the post of laboratory technician. But the petitioners have been denied promotion despite the vacancy being available. The learned counsel for the petitioner further submits that the petitioners have filed representation on 9/9/2023, 5/10/2025, 25/6/2025 to the concerned authorities, but the same failed to evoke any response, and being aggrieved, the petitioners approached this court by filing the present petition seeking the relief as aforesaid. Mr. Tagum, however, submits that the petitioners were earlier appointed under NRHM
and Edge Control Society, my lord. and under aid control society.
And under AIDS Control Society. And they were appointed as
Laboratory
contractual-
technician on contractual basis.
as laboratory technician. And most of the petitioners do not possess
Requisite qualification.
requisite qualification for being promoted to the post of laboratory technician. The submission of learned counsel for both the parties needs further consideration at this stage. Notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 and 2, since Mr. Tagum and Mr. So entered appearance and received notice. However, extra requisite copy of the petition be furnished to them during the course of the day. List the matter after 4 weeks.
Deeply obliged. Would like Your Honor.
Item number 2.
Please. My lord, basically this writ petition, my lord, challenging the impugned transfer order, my lord. There are frequent transfer, my lord, within a year for 4 times, my lord. So,
Whether affidavit has been filed?
No,
my
my
lord,
lord.
that's why, my lord, this 11-3 order dated, my lord, 11-3-2026, considering the urgency of the matter, and my lord, since interim has not been granted, my lord, as of today, there's a matter has been listed in the motion itself, my lord, and saying that affidavit should be filed by today, my lord, before today, so that matter can be disposed today. But since government has not filed affidavit, my lord, so I think government may take some more time. So my prayer, my lord, since as on today I have not been released, my lord, from my posting place, my lord. So my prayer, my lord, that till they file the affidavit, my lord, that I may be protected, my lord, so that let them file the affidavit and matter can be disposed of, my lord.
Yes, ma'am, that can be done, my lord. That can be done, my lord.
Till the
Status,
filing of the affidavit?
yes, sir, status
Till,
quo, my lord.
till returnable date, my lord.
Okay,
Status quo, my lord.
okay. Heard, Mr. R. Sonar, learned counsel for the petitioner. Ms. Wangmo, learned government advocate for the respondent.
For all the respondent, my lord.
Mr. Sonar, learned counsel for the petitioner submits that the petitioner is aggrieved for frequent transfer from one place to another place, and lastly, he has been transferred from,
My lord, I've been transferred from, my lord, the Pipu subdivision.
pardon,
Pipu subdivision.
Kivito.
Pipu, my lord, kindly find it page number 19, my lord. Impugned order, my lord. 19, my lord. My name is serial number 3, my lord. From Pipu subdivision to Pijiring
Subdivision to Pijarang.
Yes, my lord.
Pijarang subdivision. Against existing vacancy. And till date, he has not been released. Mr. Sonar further submits that though by order dated 11/3/2026, the respondent authorities were directed to file their affidavit in opposition, but the same has not yet been filed. And in that view of the matter, Mr. Sonar submits that till filing of the affidavit by the respondent authorities, the impugned transfer order dated 9th of September 2025 may be stayed. Ms. Wangmo submits that she has no objection in the event of granting such interim relief. Accordingly, taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, till filing of the affidavit by the respondent authorities on, we will fix it that.
My lord, it may happen, my lord. They may file the affidavit, my lord. Thereafter matter, my lord, when it will be listed, my lord. So, my lord, till returnable date, my lord, this may be stayed, my lord. So that.
No, I am dictating the order. Yes.
30, my lord.
30.
Yes, my lord.
30th of this month. The impugned order dated 9th of September 2025 stands state. List on 30th.
Yes.
30.
In the meantime, the state respondent shall file their affidavit in opposition. Okay.
Much
Item number 3.
Well, the case of the petitioner is that in 1993, he joined the first armed battalion of Arunachal Pradesh Police. So thereafter, there was an FIR against him, and he was suspended on 1993 itself. And thereafter, he was dismissed from the service in 1995. Well, I need not to flip on.
Departmental proceeding.
Departmental proceeding, there is a flaw. Although the presiding officers were appointed, but no inquiry officer, and I was not given the fair opportunity of being heard. Then,
Why did not you challenge the order?
No, I'm coming to that. That question I anticipated already. The reason is that, and thereafter, there was a case number 15/2020 in the Zero Police Station. So, Zero District and Station Court. There was a 29 years long protracted legal battle. And finally, he was since out of service. He stays in the interior remote China border, the petitioner, after dismissal of the service. And then recently he came to know, 2023, he came to know that this thing had happened, He has been honorably acquitted. And thereafter, then again, he files one representation on 21/11/2025, requesting for the reinstatement of the service. He is yet to retire.
When he has been acquitted?
Very recently, 23, And this order was never been communicated by the council who was handling this matter. And one fine day, he got this letter, acquittal letter, by postal through his relative that I have mentioned. So, today,
From whom he got the letter?
From one of the friend who was in the court, said कि आपको तो acute हो गया है, आपको पता नहीं क्या, the abductor did not communicate. So that has written. That what had happened is, be that as it may, till 25.
Even then, since 2023, today we are in 2026.
Correct, But I have given a categorical explanation to this, that that query, I was fully aware. My lord, kindly come to para 16 of my petition. Page 16, that the petitioner most respectfully submits that although the initial order of dismissal was passed on 24/2/1995, the present writ petition is not held by laches or unreasonable delay. The petitioner's right to seek reinstatement on fully crystallized upon his honorable acquittal by the Learned Session Court 0 on 16/9/2022 in so and so. The criminal trial remained pending for nearly 29 years, during which the time the petitioner, being of limited education, was under bona fide belief that the outcome of the criminal case was prerequisite for his reinstatement. Furthermore, upon his acquittal, the petitioner promptly exhausted all alternative remedies by filing an appeal on 10/2/2023 and revision petition on 15/9/2023. The final administrative rejection occurred only on 14/11/2023 and subsequent representation were filed as recently 21/11/2025. The primary ground for this petition, the disappearance of the sole basis for dismissal, only emerged on 2022 acquittal. The cause of action is continuous and subsisting, warranting the kind indulgence of this court. That kindly see that Captain Paul Antonio case. If the departmental inquiry and the criminal proceedings are on same set of facts, in that even the honorable acquittal will prevail over. The judicial pronouncement will prevail over. So only because that concept of no pay, no work will come, only the litigation has been filed only to an aspect of Malad for the pensionary benefits. At least something like 1.5 years he left, he will leave. So notice may issue Malad, this requires examinations.
Heard Mr. Tititara? Yes, madam, anything to submit?
Condonation petition should have been filed, Your Lordship. There is a delay, Your Lordship, in filing this writ petition also, Your Lordship.
No, 21, 5,
No,
11.
whether
21, 11.
there is a requirement of condonation petition in the writ proceeding.
Because order has been
No,
passed.
my
Your
lord,
Lordship.
the life, I just recently, I was doing one case in the dealer's case. The same question came. The life of challenging any order under his jurisdiction is 3 years, my lord.
Hmm.
If any order is being put under a challenge beyond 3 years, then you have to file the delay condonation application under Section 5 of the Limitation Act. If not, you have to make an averment justifying the reason, because whether your cause of action is a continuous process or not, my lord.
Hmm.
So that is what para 16, my lord.
Hmm.
I have given the explanation.
No. Is it provided in the limitation act
No, it's not provided.
in respect of
But
invoking the jurisdiction under Article 226?
No.
Not
It
provided.
is not provided. But
Then-
Supreme Court in one of the judgment, my lord,
You
has
have
held.
that citation?
So, but I have to check. I'll provide it. Okay. That's, my lord, that I remember. Nakap Navam Hina, the writ petition. I'll provide it. I have placed reliance in that case, my lord. Very, I think last week only we have used.
In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order. Challenge is dismissal order number PHQ, within bracket capital R, DP-66/93, dated 24/2/1995, passed by the Assistant Inspector General of Police, AP Itanagar, and also the appeal order number PHQ, which we get R, DP-66/93, dated 19/4/2023, passed by the Deputy Inspector General of Police, which we make it OPS, AP Itanagar, and also for setting aside and quashing the impugn revision order number PHQ/D-66/93, dated 14/11/2023, passed by the Inspector General of Police, AP Itanagar, and also to direct the respondent authorities to reinstate the petitioner into service with all consequential benefits, including restoration of seniority, continuity of service, notional service, area pay and allowances, and other attendant benefits to which the petitioner is legally entitled to. Mr. Tara, learned counsel for the petitioner, submits that the petitioner was serving as constable in the 1st Arunachal Armed Police Battalion. He was placed under suspension on 23rd/9/1993 in view of registration of an FIR, being FIR number 19 of 1993, for alleged assault on one cook, namely Ziri Onge, resulting his death. And subsequently, the petitioner was dismissed from service with effect from 24/2/1995 by the AIGP Arunachal Pradesh by order number PHQR DP-66/93 after a departmental inquiry. Mr. Tara further submits that thereafter the FIR number 19/93 culminated in submission of charge sheet against the petitioner, upon which session case within bracket Z number 15 of 2020 under section 302 IPC has been registered, and thereafter, by judgment and order dated 16/9/2022, the petitioner has been acquitted from the charges honorably. And thereafter, the petitioner has filed one appeal before the DIGP OPS on 10/2/2023, but the same was dismissed by order dated 19/4/2023. Against the said dismissal order, the petitioner has preferred one revision petition on 15/9/2023 under Rule 30 of the Arunachal Pradesh Police within bracket Discipline and Appeal Rules 1993. And the same was also dismissed by order dated 14/11/2023. And being aggrieved, the petitioner approached this court by filing the present petition seeking the aforementioned relief. Mr. Tara, referring to the paragraph number 16 of this petition, submits that though there was delay.
My
in
lord, I
approaching
got the
this court-
judgment. My lord, I got the judgment. It is 1995 for SSC 683, my lord. Here,
1995.
1995 for SSC 683, the state of Maharashtra versus Digambar.
Page
My lord,
number 6.
683.
Okay.
Well, in this case, my lord, what had happened? A writ petition challenging to enforce the right which was violated by the state was filed after 20 years. The Honorable Supreme Court has allowed this. So just, I will give this citation. I remember because I placed few days back. my lord.
Referring to the paragraph number 16 of the petition, Mr. Tara submits that in the said paragraph, the petitioner has explained the delay in filing the present petition and that the petitioner was residing near the China border, a remote place, and he was communicated about the outcome of the criminal case only in the year
2025.
2025. 2025. 2025. The submission of Mr. Tara, learned counsel for the petitioner, needs further consideration. At this stage, notice be issued to the respondents, returnable in 4 weeks. Step. No, you are representing all the
respondents.
Since all the respondents are represented by Ms. Basar, learned government advocate, no formal notice is required to be issued. However, extra requested copy of the petition may be furnished to her during the course of the day. List the matter after 4 weeks.
Right.
Grateful.
Item number 4.
My place, Lordship. The petitioner number in 6 is before your Lordship, is the landowners whose land has been acquired for construction of Murkong Select to Pasigat new board gauge railway line project from Leku River to 2 Mile Pasigat Phase 2 under Sile Oyan Circle and Pasigat Circle in East Siang District, Arunachal Pradesh. Now, the petitioner's land has been acquired by the authority for construction of this railway line from Assam to Arunachal Pradesh, Lordship. Accordingly, Lordship, public notice was issued. Claim and objection was sought from the petitioners. They have not, they didn't raise any objection because they are not against the project, Lordship. Now, Lordship, thereafter, the compensation was prepared. First assessment was done in absence of petitioners. It was not informed to the petitioners when the authority visited the ground site, the land. And they prepared a compensation amount and it was sent to the authority government for approval. Accordingly, government was approved. While approving the first compensation amount, of course, there was some remark from the government saying that some discrepancies are there. Some rate has not been given as per the government approved rate. And 2 genuine landowners whose name has wrongly not included in the list.
So Deputy Commissioner was directed to re-verify the ground realities with assistance of the expert. Now, on receipt of that government order, now what happened, Lordship? The Deputy Commissioner, he reviewed the first compensation assessment amount by deducting some components from her own whims and fancies, thereby reducing the compensation amount. Thereafter, Lordship, it was never intimated to the petitioner. No claim and objection was sought. Now, thereafter, directly they issued a notice saying that now you are liable to receive this much of compensation amount. You come and receive this amount of compensation from the authority. This is my case, Lordship. So, Lordship, may I take you to the annexer? First annexer is the addendum notification issued on 11/9/24, whereby the government directed the Deputy Commissioner to issue an order for acquisition of petitioner's land. We are okay. We have not objected, Lordship. Now, thereafter, public notice was issued, and then assessment, first compensation assessment was prepared at phase 37, Lordship. Here, the table they provided, but for that, Lordship, may I take you to the phase number 14 of my petition? I have categorically.
No, now what is your prayer in this petition?
My prayer is, Lordship, the press assessment has to be carried out by the authority concerned in presence of the petitioner, Lordship. At least that fair assessment should be done, Lordship. Thereafter, whatever compensation amount comes, that has to be sent to the government for approval. Now here, Lordship, by preparing second compensation amount, huge compensation bill or amount that has been deducted from the petitioners, but Lordship, they are going to make payment compensation amount from the first compensation prepared by the DC, which was approved by the government. May I take you to the one annexer, Lordship? Communication letter, phase 45, Lordship, 45. May I read, Lordship? With reference to your letter number so and so dated 10th October 2025, I am directed to convey you the government approval of the award for acquisition of additional land for railway line and ROV for the area of so and so, amounting to rupees 9,86,92,104. This amount was approved by the government on the basis of first compensation amount prepared by the Deputy Commissioner, Lordship. Now, Lordship, here by this order, the government has directed the Deputy Commissioner saying that some discrepancies are there because some component rate that has been not prepared as per the government approved rate, and the name of two genuine landowners has not been included in the list. So, direction, Lordship, last, Lordship, point number 8 of same order. The Deputy Commissioner cum collector herself may, if necessary, review, re-verify the ground realities by engaging expert in the subject himself before finalization of award under Section 37 of Act 2013. Now, on the basis of this order, Lordship, now Deputy Commissioner, he reviewed that first compensation amount prepared by them. May I take you to the comparative statement?
No, both the assessment were made in your absence.
Yes, both assessment in my absence. Now, comparative.
And the award given in the first, after the first assessment,
yes,
has been reviewed subsequently,
yes,
reduced to a considerable extent.
Yes.
Okay. Now, therefore, your prayer is for
press verification.
Press verification.
In presence of petitioners, landowners, Lordship. At least that fair practice should be adopted by the Deputy Commissioner. Now, Lordship, page number 16 of my petition, I just show you the how the variation in the amount in both assessment, Lordship.
Page number?
Page 16, 16 of my writ petition. Huge variation, Lordship. Page 16, 16.
Oh, why the second variation was carried out as per
direction of the government.
Direction of
Yes, some discrepancies are there.
On what basis the government has directed?
The government directed that, Lordship, the rate of components has been given which are not matched with the government approved rate. Government has approved, yes, component rates, but it was not given. Some discrepancies because of that. Now phase 16, Lordship, comparative statement. I'm giving, the first is the petitioner number 2, Lordship. First compensation amount, it was assessed for 23,92,045 rupees. Now, after reviewing by Deputy Commissioner, Lordship, is 16 lakhs. Variation of 7 lakhs, Lordship. And the petitioner number 1, serial number 2, his compensation first amount was 59 lakhs and 65,000. Now, it reduced to 30 lakhs, Lordship. And petitioner number 4, serial number 4, Lordship. Now, all this assessment was carried out, prepared by the Deputy Commissioner in absence of the petitioner, Lordship. So my humble prayer, Lordship, the reassessment should be done in presence of the petitioner only, Lordship.
Okay, let them file their affidavit. Thereafter, we will consider.
Yes,
And Lordship,
So the Lordship, it's hard to digest that the assessment will be done without the 1 and 2, without the presence of the petitioner.
Lordship, it's not about the digestion. This is my categorical statement saying I have not been informed. And Lordship, now they are issuing notice. Lordship, may I take you to the first impugn notice, Lordship? The language, how they use, Lordship. Lordship, page 49. Lordship. Take notice that you are assessed as project affected family beneficiary of the land which is being acquired for the above mentioned project under section 23 and 30 of LARA Act. Your award has been prepared so and so on 22 December 25 and subsequent government approval so and so, so and so. And on presentation of necessary documents, you shall be paid a sum of 30 lakhs.
Okay.
This is on the basis of second.
Let notice go at this.
Yes, and Lordship, I have interim prayer. Now they are issuing notice saying that within 7 days, if you fail to receive the compensation amount within 7 days, amount will be parked in designated court and the land will be handed over to the railway for construction. So if the possession of the land has been taken away, then the reassessment would be difficult, Lordship. So my small humble prayer, Lordship, at least, Lordship, before taking possession of the land, if re-verify could be done, Lordship.
When the notification was issued?
Notification was issued, Lordship. First notification was issued on 2024, Lordship.
24.
Yes, Lordship.
So once the notification is issued, the land is vested with the
State government, central government.
Central government now, Lordship.
Vested with, Lordship, but the position has not been taken, Lordship.
No.
No, Lordship, may I take you to the impugn reminder notice, Lordship? May I take, please, Lordship? Page 55, Lordship. Lordship. And last para, Lordship. Further, in failure of acceptance of compensation award from your end within 7 days, from the date of issue of this notice, your compensation amount will be parked in the designated court, competent court, from where.
There is no bar. It is provided in the act itself.
Yes.
That if the party refuses to accept the compensation amount,
Yes,
it can be deposited with the court.
Yes, Lordship. That part, Lordship, the next line. With respect to the compensation award may be pursued. Further, this is to inform you that the land for ROB will be handed over to the NF Railways as all codal formalities has been completed as per LARA Act.
So why don't you approach this court earlier if the assessment was made without your presence?
Lordship, first assessment, of course, we have no objected. Even we have not participated in claim and objection because, Lordship, as I have already submitted, we are not against the project, Lordship.
No.
But the manner how they're reducing the compensation first amount.
No, would it not operate as a estoppel against you?
Lordship, I am challenging the second compensation amount, basically challenging how they verify the compensation amount. Already prepared and approved by the government, thereby reducing the
There
amount.
was a direction from the government for review of the same. Re-verification of the same.
Yes, with the ground, by
Ground
visiting the
reality.
ground realities. But
Yes.
they have not done. It was, Lordship, it was not issued, that order was issued, Lordship, 25 October, Lordship, in the month of October only.
Hmm.
And this impugn notice was,
Question is, granting the interim relief is, this is difficult
Lordship, only the position,
because it is a,
Important project work, man.
it is infrastructure project.
if Lordship
Lord,
tomorrow,
at the best, they could have challenged this order for a review of the land lordship, this government's order.
Hmm.
Now it is when the already the compensation is lordship being awarded already.
Hmm.
Notice is being given to them, lordship. And then this compensation notice also this is given to them on page 49 on
Hmm.
29 December. Here is that they have said that it will be, it should be taken in within a week's time also.
Hmm.
Their main grievance is that they have lowered the compensation amount
Compensation amount.
because in the first they never challenged that first order.
Hmm.
They didn't say that they were not the party to the that assessment.
Hmm.
Just because it's lower now, they are challenging both the assessment now.
No, even the authority handed over the land to the requiring authority, then also they will not immediately start construction.
Yes.
but in that case, Lordship, my respectful submission would be if some activities are carried out, then the numbers of component may be removed from the area. So it will be very difficult for proper assessment, Lordship.
No, already two assessment reports are there.
Yes.
They cannot remove any component now.
Can that order direction may be there, Lordship? Where apprehension is on.
Will fix a sort that let them file their affidavit.
At this stage, lordship, only notice can be issued. Any kind of lordship interference will be difficult, lordship, for the state also to lordship, because since award is already out, lordship.
How, Lordship,
this
the
stage.
manner how they adopted to acquire our land, Lordship. Lordship, we are not against the project, Lordship. We are ready to cooperate with them. But our grievances only, at least fair treatment should be there. That is only, Lordship. Because how the manner they review the first compensation statement without visiting, there is a, Lordship, clear direction from the government for site verification. And the petitioner is only 5 in numbers.
Material is with you to demonstrate that the deputy commissioner has not visited the place. Not visited.
We have
the
never,
land.
we have not been informed, never informed, any notice, nothing, Lordship.
Hmm.
Nothing. Had they issued any notice for ground visit, definitely we would be there. And the petitioner is only 5 in numbers, Lordship. It's not like 100, 200 numbers, so it will take time. It's not like that, Lordship.
My lord, I am appearing on behalf of respondent number 1, my lord. On the humanist side, my lord, yesterday only, my lord, the parliament, my lord, the honorable MP, my lord, eastern side, my lord, they give big thanks to the, my lord, the Union of India for this important project, my lord. Now, in any case, my lord, if project is halted, my lord, there is a, my lord, the development activities will be greatly prejudiced, my lord. So therefore, my lord, my only submission is no, my lord, any interim at this stage. The project work is still going on in full swing manner. So therefore, my lord, only notice may be issued with the, and the affidavit is also not required to be filed by the, my lord, the Union of India, my lord, Ministry of Railway, my lord. Only the thing is, my lord, the acquisition part, my lord, if again I, my lord, make my submission in the other aspect also, my lord. If, my lord, the aggrieved person is not satisfied with the assessment, my lord, there is a provisions in the section 64 of the 2013 Act, wherein, my lord, that assessment section 64, my lord.
Okay, to file
before the district court, my lord.
Reference.
Reference.
Okay.
So if it is not satisfied with the compensation amount,
And my lord, one thing, my lord, the petitioner is not demonstrating that the what component, what articles, my lord, the properties has not been included in his compensation. His only contention is, no, in my presence, the assessment was not done, my lord. But in the absence of his, my lord, in his absence, my lord, if assessment is done, my lord, which kind of properties has not been included in the assessment is one thing, my lord. It is not the case of the petitioners that my properties and all the standings on the this so and so side has not been taken into consideration. It is not included in the compensation. Man. Only contention is, man, if in his absence, man, the compensation amount has been done. Man. Calculation has been done. Assessment has been done. Man. And for that, man, section 64 is always there now.
Regarding to reply my elder lordship, the section 64 is about the reference. It's about if the landowners are not satisfied with the compensation amount. But in my case, lordship, I'm challenging the manner how they adopted the procedure that has not been followed. Lordship.
Mr. Lowland, you say you are satisfied with the first award.
Yes, it's deemed to be because I have not objected. Right, lordship. Though it was preferred in my absence also. But I was not raised the same issue during that point of time. So now, lordship, I have shown the comparative statement, lordship.
One thing is clear that some anomalies were committed. Earlier, because I have dealt with one bail petition of one of the district land revenue officer.
DLRS.
Yes.
DLRS.
He was arrested and he was behind the bar under this PC Act.
Yes.
So while going through the case diary of that case,
lordship,
I came to know about the anomalies committed in acquiring the land. That was there. But
kind of rampant lordship anomalies.
in your absence, the assessment was made.
Yes.
It is difficult to believe.
Lordship. I've made a categorical statement, lordship. Lordship, and my lordship can see the comparative statement, how the first and second, and definitely second was done by reviewing the first compensation amount only, never visited, because direction was for both to visit the ground also.
No, there was direction of the government.
Yes.
Government, specifically to the deputy commissioner. That's why, along with the experts. Lordship.
Yes.
Maybe in the second time, that's why it was different, lordship. Deputy commissioner himself was there and along with the experts.
That has to be done in presence of petitioner. That is my respectful submission.
Okay. No, Mr. Lowland, you say if we pass such kind of order, it would amount to granting injunction against the project.
Till filing of lordship, their affidavit, if with their affidavit, if they are able to demonstrate that the petitioner was present during second assessment prepared by the authority, then lordship, I have no case.
No,
lordship.
Mr. Lowland, you say we'll fix a very short date. Let the affidavit come. We'll pass interim order later if necessary.
Till then, if
Had
lordship,
it not been an infrastructure project, then we would not have bothered to pass such kind of order.
lordship, we are also sacrificing our land, lordship.
No, that's all right.
Yes. For the interest of the state and for the nation.
Public interest is always above the individual interest.
Yes. But public land, lordship, the manner, lordship, short date may be given in the, if no affidavit filed on next date, the
Interim bear will be considered.
consider.
Okay. Heard Mr. Lowland, learned counsel for the petitioner. Mr. M. Kato, learned Deputy Solicitor General for the respondent number
One.
Ite for the respondent number
225, lordship. 2, 3, 4, and 5.
This petition under Article 226 of the Constitution of India, the petitioner has challenged the order. No, challenged the notice.
Yes, Lord.
number ESB/LM/D-50/2022, dated 29/12/2025, written with Annexure 6. Issued to the petitioner by the Deputy Commissioner, Eastern District, Pasighat, directing the petitioner to submit necessary document for disbursement of compensation, which was illegally and arbitrarily prepared without giving an opportunity of claim and objection to the petitioner, who are the project affected landowners, and also for quashing and setting aside the impugned reminder notice number ESD/LM/D-50/2022/95/106, dated 26/2/2026, being annexure number 7 series, whereby direction was issued to the petitioners for submission of deed of acceptance of compensation, disbursement within 7 days, and also for quashing and setting aside the impugned first and second compensation amount. Annexure being annexure 3 and 5, which was assessed and prepared in absence of the project land affected landowners. And also for quashing and setting aside the second compensation assessment report, Annexure 5, prepared by the Deputy Commissioner, Pasighat. After reviewing the first compensation assessment report by reducing components and resulting into huge variation in compensation amount without giving opportunity of claim and objection to the petitioners, and also to direct the respondent authorities, more particularly the Deputy Commissioner Pasighat, to re-verify the petitioner's land acquired for railway project, and thereafter assess the component and land in presence of the petitioner and prepare compensation amount, and to pass fresh compensation award under the LARA Act of 2013.
Yes.
2013. And also to direct the respondent authorities, more particularly the Deputy Commissioner Pasighat, to resign stroke not to give effect of impugned reminder notice dated 26/2/2026, and not to park compensation amount in designated court, and also not to hand over the land of ROB to NF Railway until re-verification is done. Mr. Lowland, learned counsel for the petitioner, submits that the land of the petitioner was acquired by the respondent authorities for railway project, and after verification of the land, first assessment was done, awarding compensation amounting rupees
Approval was made, Lordship. It's 9 crore 86 lakhs
9 crore 86 lakhs
92,000.
for the 7 petitioners.
Yes. In fact, Lordship, there are now 6 petitioners.
6 petitioners. 6 petitioners. 6 petitioners. And the said award was forwarded to the government, and the government has approved the same.
Yes, Lordship.
And thereafter, the government has also directed the Deputy Commissioner to revisit the
Ground.
award
Yes,
after ascertaining the ground realities.
Lordship.
Ground realities, and thereafter, the Deputy Commissioner Pasighat,
Yes.
Eastern District, has conducted re-verification and reduced the component and the amount.
Not conducted, Lordship. Now he reviewed the parts compensation amount without site visit.
Reviewed the first compensation amount.
Yes.
Without
site visit.
Without visiting the site.
Right.
Without visiting the site, and reduce the component and the awarded amount substantially from the first one.
Lordship.
Mr. Lowland further submits that the petitioners are aggrieved having conducted the second verification without visiting the site.
Lordship.
Without visiting the site, And under such circumstances, he submits that the second verification, no, second award passed by the Deputy Commissioner Pasigat, and also directing the petitioners to
Receive the compensation amount.
receive the compensation amount by impugn notifications, no, by impugn
Notice, Lords.
letters, impugn notices are arbitrary and illegal, and on such count, Mr. Lolan submits that the same may be interfered with, and till filing of the affidavit by the respondent authorities, handing over of the land to the requiring authority shall be stayed. On the other hand, Mr. Kato, learned counsel for the respondent number 1, and Ms. Ite, learned government advocate, additional senior government advocate for the respondent number 2 and 5, has opposed in granting such interim relief to the petitioner at this stage. The submission of learned counsel for both the parties needs further consideration at this stage. Notice be issued to the respondents returnable on
Lordship, short date, Lordship. Today's 16, 18.
Today's.
Let it be on 24th, Lordship.
Lordship, that is too early.
Lordship,
How can
they
I-
are asking for short date.
No, it's still, Lordship,
Lordship.
it has to, we have to write to them first, convey the
Then Lordship,
petition copies.
my Lordship may give
Do
them
it at-
sufficient time for filing a petition. In the meantime, till the next date only,
let
Lordship,
me-
handing over part.
All are statements only, allegations only. There is not much record to show that Deputy Commissioner never
Statement.
visited their Lordship. Second time also, they were not Lordship intimated, nothing is. we
Okay,
can make out from
2nd
here,
of
Lordship.
April.
2nd of April,
2nd April.
Lordship, let it be on 8th or 9th of April.
8 or 9, Lordship, I would be out of station, Lordship. Let it be on 1 or 2, Lordship, as in Lordship, 2 April.
Second.
Lordship, 3, yeah.
Lordship, this is the
He is-
petitioner.
Lordship, because he have to give us extra copies.
Extra
It will
today,
take
it says,
3 or-
right now I will furnish, Lordship.
Lordship,
No issue for it.
Lordship. Let it be on 3rd then, Lordship.
3rd April is holiday. 2nd April. 2nd April.
Lordship.
In the event of failing to file affidavit by 2nd of April, the court will consider the interim pair of the petitioner.
Lordship. Deeply obliged.
Much obliged.
Item number 5.
My lord. My lord, this is regarding non-payment of outstanding bill amount, my lord, of rupees 2 crore, my lord, approximately, my lord. My lord, Government of Arunachal Pradesh, my lord, issued NIT, my lord, for construction of Matuli and
Whether
Ali.
you have completed the project or not.
Yes, my lord. I have been subletted some work, my lord, and I have executed and completed the work. And I have paid running bill, my lord, in the year 2018-19. My lord will find in page 64, my lord. Gross amount was 61,72,865, out of which 21,83,369 has been deducted, my lord, as security and income tax and labor cess extra, my lord. And I have been paid only 39,89,496, my lord. So, my lord, I have made various representation, my lord, for payment of outstanding bills. And my lord will find, my lord, it's page 47, my lord, annexure 3, my lord. Reply, my lord, given by Office of the District Program Implementation Unit, my lord. My lord, may I read, my lord?
I am very new to the post of PIO Anini Dibang Valley district. So as we have discussed verbally over telephone as well as in person many a times on this subject, I being new to this matter, so I have no idea regarding your work done at site of PMG's Y Road, namely Matuli Aline Road, my lord. Moreover, this project is under consideration for foreclosure, my lord, as the amount left against this project is not sufficient enough to complete works left till date. My lord, I have completed, my lord, my part, my lord. I have been subletted some work, my lord, and I have completed, my lord. So I have been not paid, my lord. And thereafter, my lord, also, my lord, I have filed representation and reminder, my lord, at Annexure 6 and 7, my lord. But till that, no response from respondent authority, my lord. So this is says, my lord, my lord, notice may be issued, my lord, and with a small observation that, my lord, respondent authority shall not be at bar, my lord, for carrying out verification, my lord, of work executed and completed by petitioner, my lord. And thereafter, my lord, my outstanding necessary step may be taken, initiated, my lord, by respondent authority to make payment of outstanding bill amount, my lord.
Yes, Mr. Tara.
Otherwise, the contract agreement, all these are, anyway, let notice we go. Yeah, this is.
And my lord, observation be made, my lord.
Heard, Mr. Your name, please.
El Nosi, my lord.
Learned counsel for the petitioner. Mr. Tara, learned standing counsel for the respondent. For this, for all the authorities?
Yes, my lord.
1, 2, 3.
For the respondent. Number 1, 2, and 3. The petitioner herein is aggrieved for non-payment of the bills for the project he has executed. So, being that that is the Matuli Elini PMGSY road, within bracket 2.5 kilometers at the cost of rupees 7 crore 12 lakhs 49,000. He has been paid a sum of rupees only 61 lakh 72,865 rupees.
My lord, it's 39 lakhs, my lord. Security and tax has been deducted, my
And
lord.
out of the said amount, a sum of rupees 21 lakhs 83,369 rupees deducted as security deposit, income tax, labor cess, GST, royalty, liquidity, and an amount of rupees 39 lakhs 89,496 rupees only was paid to the petitioner as a running bill. And the remaining amount, that is rupees 2 crores,
approximately,
have not been paid to the petitioner. And though the petitioner has filed several representation for payment of the outstanding dues, the same failed to evoke any response from the respondent authorities. And being aggrieved, the petitioner approached this court by filing the present petition for issuing direction to the respondent authorities. More particularly, respondent number 3 to initiate re-verification and documentation of the work already executed and completed by the petitioner, and thereafter to make payment of the balance outstanding dues. And also to direct the respondent authorities to release a sum of rupees 16 lakhs 14,893, which was deducted as security from running bill in the year 2018-19. Mr. Tarak, learned standing counsel for the respondent authorities, however, submits that at this basis, notice may be issued to the respondents. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, it is provided that notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Tarak entered appearance for all the respondents can receive notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. Place the matter after 4 weeks.
Item number 6.
Wait. On the last occasion, my lord, time was granted to respondent number 3 and 4 to file their affidavit. They have not filed yet, my lord. So, 2022 matter, my lord. Even the respondent number 5 also has to file, my lord. Matter pertains to compensation of land, my lord. And we are alleging that there was a realignment by the highway authorities. And the secretary land management has to file because there's an affidavit filed by the deputy commissioner that says some reassessment was done and that was said, even that has been rejected, my lord. So they're required to file 3 and 4 and 5 also.
Yes, we'll pray for some more time. Actually, the problem is this thing earlier it was, taken up by this thing, standing council.
Land department had a standing council.
Standing council.
Okay. Who is the standing council?
But
No,
that
no
has,
more. We're dealing.
he's no
Government
longer
is
there.
doing now.
The government advocates are dealing now.
Okay, you filed the affidavit?
Yes.
We'll grant you short time. Heard Mr. Depanging, learned counsel for the petitioner. Mr. M. Long, learned senior government advocate for the respondent number
3 and 4.
3 and 4.
3 and 4. And you for?
Number 5.
Respondent number 5.
On behalf of ourselves.
Appearing on behalf of Mr. R. Soike.
Time for the respondent number 1 and 2.
Mr. Kato for respondent number 1 and 2. Mr. Pangyang, learned counsel for the petitioner, has pointed out that respondent number 3, 4, and 5 have not filed their affidavit in opposition till date. Other respondents have.
Others have filed. A mort is not required. Union is not required. It's a formal party.
Mr. Luang, learned counsel for the respondent number 3 and 4.
9 also, I think.
They have filed. 5 to 9 has filed.
Oh.
These are the district authorities.
No, 3 and 4 have not.
Yes. He says 9 also. That's right.
3 and 4 have not. Learned counsel for the respondent number 3 and 4 submits that he may be granted some more time to file the affidavit in opposition. Yes, you?
And for respondent number 5.
5, yes. 5 has also not filed the affidavit in opposition.
5 is required to file, my lord, that highway authorities.
Okay. Accordingly, it is provided that recess shall raise the matter after 2 weeks. After 2 weeks. And in the meantime, respondent number 3, 4, and 5 shall file their affidavit in opposition.
Right.
In the event of failing to file the this next day, the court will proceed to hear and dispose of the matter without their affidavit.
Right.
Item number 7.
Hello, this bill pending matter, but however, the petitioner has expired last year. So in this regard, legal representative need to be filed for conclusion or to continue the case.
Whether you have received any inspection?
No, I have not. I need to inform the petitioner. So for filing legal.
Implement petition. You have to file implement petition for the legal heirs.
Yes.
Heard Mr. M. Nigo, learned counsel for the petitioner. And Mr. Luang, learned senior government advocate for the state respondents, all the respondents. All the respondents. Mr. Nepal submits that the petitioner here in this petition has suffered demise. And he will obtain instructions for implementing the legal heirs of the petitioner. Then he press for listing the matter after 2 weeks or 4 weeks.
After 2 weeks.
After 2 weeks. Here allow presses a list the matter after 2 weeks.
Obliged, my lord.
Item number 11.
Yeah, please, Lord. My lord, the petitioner herein is, my lord, challenging the legality of order passed by the deputy commissioner, my lord, as an appellate authority under Arunachal Pradesh Eviction of Unauthorized Occupant Acts 2003, my lord. My lord.
Where is the impugn order?
My lord. Impugn order is at page 23, my lord. It's order dated 27/8/2024, my lord. My lord, I will read the relevant part only, my lord. One, my lord. Paragraph 1, my lord. My lord, Srimati such and says occupied on such as has submitted an appeal against the order dated 23/7/2024, passed by the additional deputy commissioner, who is the state officer, my lord, hearing. Now, thereafter, my lord, the paragraph 5, my lord. Sri Kemi Rivia appear on behalf of Sri Kimesai, the petitioner herein, former occupant of government quarter number association. He submitted that the government quarter number was earlier allotted to his father Sri Kimesai, that their family is large, and upon retirement of his father, they have made some construction near the government to accommodate the family. No damage has been done to the government quarter, and more so, 1 meter gap was also maintained with the boundary of the appellant. However, there is no land allotment against this field, and no any permission was obtained for construction of building nearby the government quarter number 12, type 1. And thereafter, my lord, I will take lordship to the operative portion, my lord. Paragraph 11, page 24. Page 24. Father Sri Kimesai, paragraph 11, my lord. Father Sri Kimesai has no land allotment in his name where he has made the construction of RCC structure. The construction of any structure in public premises without any permission from the competent authority is illegal and unauthorized itself. In view of above and taking into consideration of all the material facts, the Assistant Commissioner Itanagar is hereby directed to seal the unauthorized building construction of Sri such and such within 7 days from today until further orders. The order passed by the ADC Itanagar dated 23/7/2024 automatically stand vacated with this order, my lord. My lord, kindly see page 23, my lord. Just above the course title, my lord.
Okay, we will resume after 5 minutes.
My lord. My lord.
Yes.
My lord, page 23, my lord.
Page number?
23, my lord.
23, yes.
Yes, ma'am. My lord, kindly see above the course title, my lord. But this order was passed under section 12 of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2023, my lord. 2003, my lord. Sorry, 2003. My lord, the contention of the petitioner is that, my lord, the learned deputy commissioner, while acting under section 12 of the act as an appellate authority, has no power under the act to make an order to seal the residential building of the petitioner, my lord. My lord, as my lord, appeal is filed before him, my lord. At the most, he has power to remand the matter back to the state officer for passing a necessary order under section 5, 7, 8, and 10 of the act, my lord. Now, my lord, by this order, he has directed to seal the residential building of the petitioner, which he cannot, my lord. My lord, and my lord, to substantiate my contention, my lord. For the moment, may I take your lordship to the section 12 of the Act, my lord. Arunachal Pradesh, volume 8. Yes, AP code.
Page number?
Page number 16. Well, I'm sorry. This page number 160.
160.
160. My lord, I will take your lordship to page 169, my lord. Section 12 is at page 169. My lord, section 12, my lord. May I read, my lord? An appeal shall lie from every order of the state officer made in respect of any public premises under section 5 or section 7 or section 8 or section 10 to an appellate officer who shall be the deputy commissioner of the district in which the public premises are situated. My lord, the section 12, my lord, clearly spell out, my lord, what order can be appealable before the deputy commissioner, who is the appellate authority, my lord. My lord, it speak about section 5, section 7, section 8, and section 10, my lord. My lord, I will skip section 5, 7, and 10, my lord. May I take lordship to section 8, my lord. Page 166, my lord. Power to seal unauthorized construction, my lord.
Section 8.
8, my lord. My lord, kindly come to my lord, Roman 2, my lord. My lord, I'm sorry, my lord. Roman 1, my lord. It shall be lawful for the state officer at any time, before or after making an order of demolition under section 7, to make an order directing the sealing of such erection or work or of the public premises in which such erection or work has been completed in such manner as may be prescribed, for the purpose of carrying out the provision or for preventing any dispute as to the nature and extent of such erection or work, where Roman Tumela, where any erection or work or any public place in which any erection or work is being carried on has have been sealed, the state officer may, for the purpose of demolishing such erection or work, in accordance with, this is not so relevant, my lord. One is relevant, but Roman 1 is relevant, my lord. My lord, my submission is that, my lord, this sealing order has to be made by state officer, my lord. And my lord, against that order, my lord, if anyone is aggrieved, my lord, he can make an appeal under section 12 of the Act before the deputy commissioner, who is an appellate authority, my lord. My lord, in this case, my lord, there is no any, my lord, order under section 5, 7, 8, or 10 against the petitioner, my lord. My lord, I'll take your lordship to.
You see, whether the issue is whether the appellate authority can issue such an order or not.
Yes, my lord. My lord, section 12 clearly spell out, my lord. No, my lord. Until and unless there is order under section 5, 7, 8, and 10, my lord. That is what section 12 says, my lord. My lord, kindly see, my lord. Thereafter, my lord, I will come to the fact of the case, my lord. I'm not. So,
No, you
now
come to this section 12.
Yes, my lord.
If there is any bar
My
in ordering by the appellate authority.
Yes, my lord.
To seal the unauthorized building construction.
Yes, my lord. My lord, section 12 is very clear, my lord. My lord, so in my humble submission, my lord, at the most, my lord, he will remand the matter back to the state officer, my lord. My lord, there is order of the state officer, my lord. During the pendency of that, my lord, proceeding under section 4 of the Act, my lord, the landed state officer has passed an order, my lord. Interim order, my lord. Against that interim order, this private respondent number 5, my lord, has
file an appeal before this deputy commissioner, my lord. Well, therefore, my lord, may I take your lordship to the how this case has been arisen, my lord. My lord.
Yes, madam, whether the appellate authority has such power under section 12.
Lordship, in the order, there may be some lordship mistakes here and there. But then the situation here, lordship, has forced him to lordship, because lordship will see in my annexures only the way this petitioner have raised the structure in between the two quarters, lordship. The petitioner's son has built. Petitioner has retired already, lordship. In the this one also, lordship, when the matter was heard, also his son is attending, lordship. Page 43, lordship, will see the structure, lordship. 43. He have uprooted the fencing in between the quarter, and he have built this structure. And second structure, lordship, see how it's posing and crossing the quarter and posing threat, lordship. Next, this blue colored one is his building, lordship. This situation has made him pass this order, lordship. Of course, it was dealt by the ADC already. So in the appeal, lordship, the deputy commissioner have added some, lordship, much needed order, lordship.
No, that's all right, but he has to exercise his power within the framework, legal framework of section 12.
Yes, lordship.
He cannot go beyond that.
That's understood, lordship. Lordship, otherwise also the petitioner have the stay here, lordship. But then I don't know if the building is they are still building or is still in the same position. It's unauthorized, lordship, construction.
May I, my lord, suggest, my lord? My lord, let this matter may be remanded back to state officer who will taken care of everything, my lord. My lord, clearly I'm submitting, my lord. Let this matter, let this interim order is set aside, my lord. It will be remanded back to the state officer. My lord, he will taken care of everything, my lord. I'm purely submitting, my lord. If there is any encroachment, my lord.
I pray that some observation maybe when I was in between,
No,
they will.
admittedly, the land was not allotted to you.
Yes, it seems
So
like
then how can you construct the quarter or construct the building?
Without any permission, lordship.
my lord, that's why, my
Under what authority?
my lord, if I say, my lord, kindly come to the my petition.
The quarter was allotted to your father.
Yes, my lord.
And within the vacant land, and now by removing the quarter, you are constructing your residence there.
My lord, kindly come
Building
to.
there.
My lord, kindly come to the
Part of the quarter and then fencing in between the quarter.
order passed by the state officer, my lord. My lord, this matter is pending before the state officer till that, my lord. Kindly page 21, come to the page 21, my lord. This is the order passed by the additional deputy commissioner, who is an state officer, my lord. My lord, the order dated 27/2024, my lord, against which this order appeal has been filed, my lord. The Director Housing Government has submitted a report to the landed Deputy Commissioner Capital Itanagar stating that on receipt of complaint from such and such occupant of such and such native the housing staff has inspected the premises on such and such, found that Sri such and such had enclosed a setback between quarter number such and such and uprooted and boundary fencing by art cutting, and they are causing threat to the quarter, making it prone to soil erosion and landslide. The learned Deputy Commissioner Capital Itanagar has endorsed the matter to understand for necessary action. Today, the matter is fixed for hearing both the parties. Miss Such and Such is present, who is residing in government quarter number such and such, Niti Vihar, Itanagar. Mr. Such and Such, residing in quarter number such and such, is present. Sri Kamesai, respondent residing near government, is also present. On perusal of the records and after hearing both the parties, it is hereby ordered that Sri Kamesai to erect protection wall backside of government quarter number such as to the front of quarter. The front protection wall will be 3 meters in length. The protection wall will be completed by end of November 2024. Ms. Such and Such is hereby allowed to monitor the progress of work and is free to oppose this court whenever needed, my lord. My lord, in my humble submission, my lord. My lord, issue is all.
No,
Yes,
whether this matter is pending before the state officer now.
Yes, my lord. My lord, by this impugn order, my lord, this order has been already also vacated, my lord. My lord, page 25, my lord.
Lordship, since other party has already appealed against this order, Lordship.
My lord, this is interim, in my humble sense, interim order, my lord. Against this order, the complainant, my lord.
In the section 12, it is stated that any order
passed by the ADC.
Yes.
Yes.
My lord, any order
It
passed by
goes, Lords, after disposal,
every order,
that order.
not any order, from every order.
pass under section 5, 7, 8, and 10, my lord. It's specified, my lord. But this order is not passed under section 5, my lord, or 7, 8, or 10, my lord. This is just interim measure, my lord. As an interim measure, this has been because there is allegation that since because of the land art cutting, there is chance of landslide, my lord. That's why this interim measure, as an interim measure, this order has been passed, my lord. And against this order, they have filed an appeal, my lord. Instead, my lord, they have to approach the landed state officer to dispose their complaint in accordance with law, as per section 4 of the 4 of the act, my lord.
Lordship, because other party knew the art cutting was done to start construction. That's why they have gone for appeal.
My lord, in my humble submission, my lord, let this matter may be remanded back to the state officer, my lord. My lord, state officer will, my lord, taken care of everything.
Before passing such a remand order,
Yes,
you
my
have to satisfy this court that the impugn order is illegal or arbitrary.
My lord, yes, my lord.
You have to demonstrate it.
Yes, my that's why, my lord, I have, my lord, kindly appreciate section 12, my lord. What it says, my lord. It's clearly spelled out, my lord. But there should be order under section 5.
You see, this order of the ADC appears to be passed under section 7.
Yes,
No,
Lordship.
my lord.
Though it may not be mentioned, Lordship.
My lord,
It's page number 21.
yes, my lord.
Though the section has not been mentioned,
My lord, in my humble understanding, no, my lord.
Hmm.
Well, demolition order is, section 7 is demolition order, my lord. Section 7 is demolition order, my lord. To demolish the structure, my lord.
But then lordship, public premise means lordship, any land and building belonging to the government, state government, lordship.
No, such erection of building or execution of work in contravention or not authorized by any such authority. Yes, anybody for the private respondent?
Yes.
You are?
Yes. This case, Madam, there are two poles. One pole is unauthorized occupant.
Mm.
And the second is construction of an illegal structure.
Mm.
Section 4 and 5
Mm.
of the Act, Madam, it deals with the unauthorized occupant.
Mm.
And the section 6, 7, and 8, it deals with Madam, illegal structure.
Mm.
So, Madam, section 6 prescribes that any erection of illegal structure,
Mm.
then, Madam, this section 7 will come into play.
Mm.
Demolition order.
Mm.
But Madam will see this section 8.
Mm.
Prior to the passing of demolition order, an order of sealing has to be passed.
Mm.
Section 8. Therefore, this appeal was rightly prepared before the DC,
Mm.
which is as per in subsequent to the section 7 of the Act.
Mm.
Because this sealing order was passed under section 8 of the Act. Then, it comes that appeal is the continuation of the original proceeding.
Mm.
Therefore, this impute order has been rightly passed by the appellate court.
Mm.
As I have seen, there is no such infirmities in the impute order. There is one thing. Secondly, in this case, I bring the complaint in my complaint petition as well as in my appeal petition. I have categorically alleged that there is illegal structure.
No, you tell me one thing, the original complaint is pending before the ADC, state officer. It has not been disposed of.
As of now, it has been disposed by this impute order.
Disposed of?
Yes.
Okay. Okay.
So since this state officer was only confined with the section 4 and 5 only, whereas I have also alleged the violation of section 5, 6, and 7. So that has to be taken care by the state officer. Therefore, this appeal was filed under section 12. And rightly, in accordance with the section 7, this appeal has been disposed of. So there is no illegality. And even this section 107 of CPC, it says appellate court can also exercise those power which are vested with the original court. There is also there.
Section
107 of the
107 CPC. Yes.
subsection 2. The procedure in this act has been acted in a completely in a civil nature. Therefore, this section 107 CPC will also be have some applicability in this act. So therefore, those power which has not been acted by the original, it can also be acted by the appellate court by the virtue of this section 107. So, Malo, I believe there's no nullities or any infirmities in the interim order, and I'm completely brave for dismissal of this state petition.
May I take lordship to the page 31, my lord? Affidavit filed by the respondent, my lord, state respondent, my lord. They have also admitted that they have no power to.
Pardon?
They have no power to pass any order of eviction. Page 31, my lord, paragraph 9. Page 31, paragraph 9, my lord. My lord, 1, 2, 3, 4, 5, 6, my lord, 6 line from bottom, my lord. Since your, I will also quote, my lord, 6 line from bottom, my lord. Since your deponent being the appellate authority cannot pass any eviction order and in order to prevent from further construction, the order was passed and directed the commissioner from state of to seal that.
This affidavit would not change the legal position.
Yes, ma'am. But legal position is, my lord, in my humble understanding, my lord, is under section 12, my lord. There must be order, my lord, under section 5, 7, 8, and 10, my lord. Until and unless there is an order under section 5, 7, 8, and 10, my lord. My lord, this section 5 order is after the procedure followed under section 4 of the act, my lord. After section 4, this section 5 order will be come into play, my lord. My lord, in instance case, my lord, though my lord, complaint has been made to the state officer, my lord, and this state officer, after taking cognizance, my lord, this order has been passed. This order is not final order in my humble sense. It is a temporary.
No, the proceeding has been closed before the state officer. It is not pending now.
No, my lord.
No, the counsel for the other side, private respondent has already submitted that it has
My lord,
been
that is
closed.
not their statement in that is not stated in their, my lord, affidavit, my lord. It is not pending, my lord. I have specifically about in my
Is it correct that the proceeding is not pending there?
No.
No, it is pending there. No.
Well, they have to answer, yes, my lord, they have to answer my amendments, my lord, which is made in my writ petition. I have specifically about it. It is pending before the, my lord, the learned state officer, ADC come state officer, my lord. And that has been not answered by them, my lord. Meaning thereby, my lord, they are admitting that it's pending before the state officer, my lord.
Madam, can I obtain instruction regarding pendency of this proceeding before the state officer?
Can you tell us petition number 25 of the state petition?
25, yes.
It's paragraph 13.
Yes.
Before we take into consideration of all the material fact that the commission you see the unauthorized building construction of the previous site within 7 days from today until further order. The order passed by the ADC Itanagar dated 23/07/2024 automatically stand vacated with this one. There remains nothing before the state commission.
Well, that has been stated, my lord, by this honorable court, my lord. This order has been stated, my lord.
Hereafter, no proceeding has commenced.
No, since my lord, petition is pending before this honorable court. The proceeding cannot be, my lord, proceed before this state officer, my lord.
Better do one thing, madam, you please obtain instruction whether this proceeding is pending before the state officer or not, or it has been closed.
Lordship.
We will list this matter on Monday then.
My lord, Monday, my lord, I have personal difficulty. My lord, after tomorrow, my lord, I will leave for my native. for a month.
Tomorrow there is a DB.
Tomorrow after DB, my lord, I will leave left from my native, my lord, because of my.
The question is whether madam can obtain instruction or not.
Lordship, telephonically, I will try to obtain.
My lord, let it be written, my lord. My lord, let it be written, my lord, in my humble system. Let it be written, my lord. Telephonic will not do. Otherwise, my lord, in my humble submission, my lord.
Lordship, to my understanding, it won't be pending anymore because by this order itself, it was, though it has been stayed, Lordship.
Anyway, even then you obtain instruction whether it is pending or not.
Lordship.
Only that purpose. Should we list it tomorrow then?
Tomorrow.
Tomorrow, DB.
Or day after tomorrow?
My lord, I will leaving tomorrow after DB, my lord. My lord, our, my lord, Miyoko.
Lordship,
please,
okay, I will try to obtain.
Tomorrow?
Yes.
Day after DB?
Yes.
Okay. Okay. Heard Mr. Lampu, learned counsel for the petitioner. And Ms. Ite, learned government advocate for the respondent number 1, 2, 3, 10. Mr. Your name, please? G. Riba, learned counsel for the respondent number 4. Heard in part, list the matter tomorrow.
My lord.
Yes.
Obliged.
As part heard.
Obliged.
In the meantime, Ms. Ite, learned additional senior government advocate shall obtain instruction as to whether where is the number of the case?
My lord, I'm sorry. Page 21, my lord, I think, page 21.
Is it the number?
Number, page 21.
Page
Yes,
23,
ma'am.
Lordship.
No, number, this number. Before ADC.
Yes. Before ADC, Lord. This is.
Page 21, madam. Number is DCICC 17. Yes,
Okay. Whether the proceeding under Arunachal Pradesh
Public premises.
Public Premises Eviction of Unauthorized Occupant Act
2003, ma'am.
2003, being proceeding number DC-ICC-17013/21/2024 is still pending before the Court of Learned ADC.
Come state officer.
Come state officer. Then appraise this court by tomorrow.
Lordship.
All right.
Item number 13.
Lordship,
Yes.
Lordship, I am appearing on behalf of the petitioner. Your Lordship, this matter was listed on 23/10/2025 for motion. And as per the last order was supposed to be listed on after 3 weeks. But unfortunately, this matter could not be listed after 3 weeks. It's been long time. So, Your Lordship, as per last order, this honorable court has, as per the last order, this honorable court has reflected in the last order that my interim prayer will be considered on the next date. So, Your Lordship, as far as I have my associates over there, so what information I have received is that till now the state, they have not filed their affidavit, Your Lordship. So, I'm praying before the honorable court that my interim prayer may be considered, Your Lordship. And in the interim order, Your Lordship, there was no such direction that my salary would be stayed. But since then, Your Lordship, my salary has been stayed and I am not getting my salary, even though I am under suspension, Your Lordship. So I'm facing financial hardship, Your Lordship. So I'm praying before this honorable court that state respondents may be directed to release my
Where is the
pending.
impugn order? Where is the impugn order?
Your lordship, interim order is at.
Impugn order.
Yes, yes, your lordship, that is page 56, your lordship, 56 to 56, that is annexure 10, then annexure 11, and yes, annexure 8, 9, and 10, your lordship. That is page number 53, 54 to 55, and 56 to 58, your lordship.
No, this is the page number 57 is the release order.
Yes, yes, yes. Your lordship, what happened in this case? Exactly is that till the time I was in service, I was serving as executive engineer under NST, Arunachal State Transport. So I was being transferred to.
Mr. Soren, you were impugning the order dated 7/5/2025. Where is that order?
Your lordship, as per my petition, there are 3 impugn order, your lordship. That is annexure 8, annexure 8, annexure 9, and annexure 10, your lordship. That very order, when I was transferred, your lordship, what happened actually where I was transferred, I being an executive engineer, the where I was transferred at Tinsukia, Assam, there was no such post for executive engineer. There was only post of assistant station superintendent, that is in short ASS. So your lordship, I being the senior in rank, how could I be transferred in such a place where there is non-existent of executive engineer post? So that is why I challenge this order. But in the meantime, even I had made representations that since there is no such post for executive engineer in Tinsukia, Assam, so to please reconsider my this transfer order. But state respondents, they did not reply, and instead they have continued in their this first transfer order. Accordingly, I was transferred from as per annexure 10. Then I was released from.
Mr. Ratan.
Yes, madam.
Why his salary has not been paid?
My lord, this very writ petition is challenging his transfer order. Now, he has not made anything saying that he has been suspended. He has not stated that. In fact, he has approached this honorable court without challenging the suspension order.
Okay.
Suspension was done on 12th of August 2025. This is not impugn in this writ petition. He is only challenging his transfer order and his release order, whereas he has already been suspended because of non-joining in the transfer place of posting, and there are some allegations against him.
Okay.
So how can he say that just because he has been transferred, so he is not being paid? He has been suspended.
Okay.
Lordship.
And this suspension order is not under challenge. This, my lord, will see the prayer is for setting aside his transfer order, release order, and for consideration of his representation against those transfer and release order. But he has not stated anything in this writ petition saying that he has been suspended. Now he is making a.
Before filing of this writ petition,
He has been suspended. My lord, he has filed this writ petition in the month of October. He was suspended in the month of August, 12th August.
Okay.
I don't know how.
Why should we not dismiss this petition for separation of material facts?
With cost.
Lordship, let me explain this. Actually, what happened, there was miscommunication between me and my client. And after the hearing of the motion of this case only, my client has sent me that suspension order. So your lordship, during that time while we had filed this petition, it was not within my knowledge that he has already been
Then he should have
suspended.
withdrawn it without.
Better, Mr. Suren,
Please let
He
me
should have
continue. Your
immediately withdrawn it without making a
Your Lordship,
submission for
having said
hearing in the
that,
interim. He should
I'm
have been
saying
fair
that
to the court.
even if in my suspension order, if there is any averment which says that during my suspension, my salary has to be stayed, whether that averment has been made in my suspension order or not. If that is not so, then what we are saying my
Mr.
salary.
Surin, Mr. Surin, you see this suspension order is not challenged in this petition. It is
Lordship.
not part of the record. You have suppressed it.
Lords, no,
And by
Lordship,
suppressing material facts, you have approved this court.
I have not suppressed it. During that time, it was not within my knowledge, Your Lordship. I
No,
have not.
you please listen to me. Better you withdraw this petition and you challenge the suspension order.
Lordship, because after filing this only, it has come to my knowledge that the petitioner has already been suspended from service. So that is how I could not challenge that suspension order of mine. Your Lordship, having said that, if Your Lordship could be very humble or leniency to show that in my suspension order only, there is no such order that during my suspension, my salary could be stayed.
No. We cannot consider that submission because the suspension order is not part of the record and not been challenged in this petition.
Lordship. So Your Lordship,
Better
Your
you withdraw this petition and file a fresh, we will grant you liberty.
Yes, Lordship, I may be allowed to withdraw this petition to file a fresh, Your Lordship, because
We
now
will
again.
grant you liberty. Okay.
Lordship.
Okay. Heard Mr. Surin, learned counsel for the petitioner. Then Mr. Roton, learned counsel for the respondent. Authorities. During the course of deliberation, Mr. Surin submits that the petitioner has been suspended and he has not been paid salary. However, to a pointed query of this court, Mr. Surin submits that the suspension order is not impugned in this writ petition. Mr. N. Roton, learned counsel for the state respondent, producing the suspension order dated 12 of August 2025, submits that before filing of this petition, the petitioner was placed under suspension for not joining his duties in the new place of posting. And as such, the petitioner may withdraw this petition and
awarding contracts, malpracticing in awarding contracts, my lord.
Awarding?
Contracts. He has awarded contracts also, unauthorizedly.
Okay, that we will see.
In the suspension order, my lord. My lord will see. Is underway in connection with malpractice in awarding work contracts.
We will not record it because it is not part of this.
Yes. My submission.
And the petitioner may be directed to withdraw this petition and to approach this court again by filing appropriate petition. Mr. Surin, learned counsel for the petitioner, also submits that he may be allowed to withdraw this petition, granting liberty to approach this court again by filing appropriate petition. Accordingly, taking note of the submission of learned counsel for both the parties, Mr. Surin is permitted to withdraw this petition. However, a liberty will remain with the petitioner to approach this court again by filing appropriate petition. The suspension order of the petitioner produced before the court today by Mr. Roton shall be marked as Annexer A and be tagged with the record.
Lordship.
Item number 15 to 17.
May I please, Your Lordship. Item number 15 to 16, 17. 15 is for the compensation under Schedule 2, and then 16 is for the solution, and then 17 is for solution and the compensation under Schedule 2 of the LARA Act. Well, in this case, affidavits only Deputy Commissioner has filed, And then secretary and director, they have not yet filed the affidavits, my lord.
In all the three matters.
Yes, all the three matters.
In fact, my lord, basically all three matters relates to some sort of compensation. The compensation has to be paid by the Ministry of Civil Aviation if they are entitled to. And therefore, they are necessary parties. Ministry of Civil Aviation and the Airport Authority of India. They are not made parties. Only the state respondents are made party. State respondent is will be able to pay the money if they grant, if they are entitled to, if they succeed. So they should have included the parties, central government, Ministry of.
Whether you have filed your affidavit or
Oh, we have Deputy Commissioner. We have filed.
no, for other respondents
Other respondents, Deputy Commissioners, this will
be sufficient.
yes. But in the event it is required, we'll ask the
Who
secretary.
is the requiring authority?
Requiring authority is the Airport Authority of India.
Airport Authority of India is not a party.
Not a party. The Airport Authority of India is
Civil Aviation.
civil aviation. They are not the parties.
Mr. Mao, you bleed them?
Yes, then I can implement, my lord.
If otherwise, even if he succeeds, again, if the money from where the money has to come, if they are not parties.
Okay.
I mean, meantime, we can implement, my lord. We can file IA for implement.
Yes.
Meantime, the secretary also can file.
Yes, first you implement, let them also. Why are you rushing for the secretary? We have at least the deputy commissioner has filed.
But matter has pending for a long time.
Yes. You should have.
Mr. Mao, learned counsel for the petitioner, and Mr. Rotan for the
State respondent.
respondents. Mr. Rotan submits that in all these three matters, the requiring authority is the Airport Authority of India, but the state authority has not been implemented as party, though the Airport Authority of India and also the Ministry of Civil Aviation are necessary party in this writ proceeding. And as such, Mr. Rotan submits that if any compensation has to be paid, that has to be paid by the aforementioned two authorities, and as such, they are necessary party and they may be pleaded in this proceeding. Mr. Mao submits that he will file impleadment petition for impleading the Airport Authority of India and also the Ministry of Civil Aviation as respondent number.
Yes.
5 and 6.
Yes, respondent number 7, no, 6 and 7.
In 108, it shall be 5 and 6.
108.
In 108, it is
6 and 7. 6 and 7.
6 and 7. However, Mr. Mao has also pointed out that the secretary, the respondent number 2, has not yet filed the affidavit in opposition. Accordingly, it is provided that Mr. Ratan shall file affidavit for the respondent number 2 before next day.
Yes, madam.
Yes.
Release the matter after?
Well, 2 weeks, madam.
After 2 weeks.
Yes. Well, then the 107, madam.
First, let them implement, madam. Otherwise,
we have to implement. Then we will implement all the petitions, madam.
All the 3 petitions you have to file.
Yes. Yes.
First, let them implement. Then our affidavit we can file it.
No, you can file it.
Yes.
Where is the bar?
Yes, madam.
Yes. Let them first implement because my lord is giving only 2 weeks. My lord is giving only 2 weeks time. That's why I'm saying for filing affidavit.
Okay.
Obliged.
Obliged.
Item number 18.
My lord, may I plead your lordship? My lord, 18, my lord. This matter related to my lord, payment of admitted pending bills, my lord.
Admitted
Pending bills.
pending bill.
Yes, my lord.
What is the amount?
Amount is, my lord, 12 lakhs, my lord.
12 lakhs.
Yes, only 12 lakhs, my lord. Full amount payable, my lord.
Madam Basar, why it has not been paid?
Your Lordship, NBS is the main party, Your Lordship. He has this, we have actually given it to the Arunachal government UD department for construction of a NBS girls hostel, Your Lordship. Your Lordship, if Your Lordship come to my affidavit, because we have given the reason.
Page number?
Your Lordship will come to page number 71.
The affidavit file. Affidavit file.
Consola,
I think it's
no, this is I.
it's marked in the it's it's in the file.
Okay, here.
Yes.
Green place? Affidavit by respondent number 1 and 2. You offer the respondent number 1 and
3, Your Lordship.
3. Respondent number 3. Okay.
Your Lordship will come at page number 71, Your Lordship.
71. Yes.
We have written to the chief engineer stating that some of the were not found and it was given in annexure 1. Your Lordship will then come to page number 72. Page,
72.
at page number 72, Your Lordship will see up above is the checklist for final bill. So these are the documents that we required to finalize the sanction of the release of the bill, Your Lordship.
You requires these documents from home.
From because we have given the department for execution of the work. Now the department has given it to the petitioner herein, and they have made an agreement for execution of the work. Now our part is that the building has been constructed. Now we are seeking the documents from the department that you give us those documents to release the bill. There are certain documents that is not with us, Your Lordship. They had also replied, Your Lordship, and then Your Lordship will come to page number 73. So they have made an reply to the application on 4th of April 2023, stating only that the final RA bill is to be released, Your Lordship. At page number 74, we have immediately replied back stating that these are the documents which are required for release of the bill, Your Lordship. So subsequently, this went on till, if Your Lordship will then come finally to page number 81, which is the last page, Your Lordship. So this is the last letter dated 7/4/2025, where it states that your office so-and-so submitted the documents for settlement of the final bill. On examination, it has been noticed that the completion date so-and-so is 5/6/2015 against the JNB stated as 8/10/2015 and NBRS RO stated as 23/3/2017. The said discrepancies need to be justified. It is also noted that in handing taking over of the above mentioned work, the completion date has been stated as so-and-so, where signature of NBS RO Shillong, principal and Dudar available. In this regard, it is request to review the proposal of final bill and EOT, considering the date of completion of works as mentioned in the handing taking. So these are the only grounds that we want, the information that we required from the department, Your Lordship. That the finalization of the bill is only.
These are the communication between the departments.
Department.
So why he should suffer?
Why I should
Because we are to release the bill, Your Lordship. We have given the work to the department, Your Lordship. Now department, and they have made an agreement. We are not part of the agreement, Your Lordship. Now we are ready to pay on subject to this completion of certain documents that we require. during the entire execution process, there are the bills and the date of extension because it was of,
You obtained the documents from the other departments.
no, if your lordship will come to page number 69, your lordship. 69 is,
I think, madam, I think this is, I think,
we have given the entire project to the Department of Urban Development and Housing, Government of Arunachal Pradesh, your lordship.
I think my lord will be pleased to see page 27 as in my read petition, my lord. The completion was in 2015. How long there can be a corresponding 2015, my lord. Completion was in 2015.
Okay.
Page 27, my lord. There's a letter from the Deputy Director, Urban Development Housing.
So the interest will be double. We'll direct you to pay 18% interest.
We are ready to pay, your lordship, the pending bill, subject to the condition that those documents, because we have given the work to the department. Now, department has.
Problem is that for 10 years, you have failed to obtain the documents and release the bills.
Yes, my
Your
lord.
lordship, the final bill was prepared in the year 2024. But we have not made any agreement with the private party. He has just executed his work.
You were supposed to pay.
Yes, we are ready to pay, your lordship. Your lordship is well aware that
Representing the department.
yes.
Since 2021, your lordship, we are communicating to the MBS, your lordship, for payment, your lordship. And last communication we have done on 7 June 2024. Your lordship. And we have filed this affidavit on 3rd April 2025, your lordship. And after that only we have he has filed this affidavit and annexed the recent letter which they have sent to us. It is on 7th 4, your lordship.
25.
This letter to seek instruction, your lordship. Because while filing this
7-4.
affidavit, yes.
Where is that or letter?
Page number 81, your lordship, of my affidavit.
It is before receiving this letter, we have filed our affidavit, your lordship.
Hello, that is between the two departments, but then, my lord, my bill is pending since completion in 2015, and then bill is paper late, but then still it is corresponding between departments. So, my lord, I will pray that this matter can be disposed, directing the both the departments to sort out and pay compensation within a time frame, my lord, with the interest, my lord. That can be disposed of.
My humble submission.
Because otherwise, pleading is
We don't
complete.
have any
Pleading is complete, my lord.
In inception, we don't have any issues with regard to payment, your lordship. But our payment directly goes to the account of the Department of the UD. Now they have to give us an explanation to certain documents that while executing because the work was given to him by the department. We are ready to pay except for subjecting to the documents that we need, EOT documents, your lordship, and the other necessary documents, only that much. Now, if they want to reply to this application, because the last letter of 7/4/2025, your lordship.
No, reply, everything is done.
Almost a year over.
Yes.
Because from our side, your lordship, we are communicating to pay the amount, your lordship.
We are also replying back, but then that proper documents are not coming to us. That's the only, because we don't have any issues paying, your lordship. And in fact, it's not even.
In that case, we will direct both the parties to solve the issue.
Yes.
And make payment of the bill within a time frame.
Yes, my lord.
Otherwise, the amount shall carry interest at the rate of 18% per annum.
Yes, my lord.
Yes, your lordship. Your lordship, I completely agree to that, your lordship. However, if your lordship, while also disposing in this matter, also rely to the last communication that we made to the department, your lordship.
And the interest will accrue from the date of filing of the final bill.
Yes, my lord. But it should be from the date of completion, my lord. Otherwise, my case is that I have completed the work.
No, who prepared your bill?
That is department.
It is by the department.
Only.
By the
Department. We have only to release the amount. And department is not giving us the entire documents that is to be required, Your Lordship, for release of the bill.
Recently only, Your Lordship, they are saying this, their documents are not complete.
Ani, 2021 say na.
No, for home, for
2024 say.
whose lapse, the documents could not be completed.
On the lapse of the department, Your Lordship. Because if Your Lordship will see, we have communicated on several occasions. From the first time when the bill was given in the 2021, Your Lordship will see at page number 70. 70 is the first final bill that was, the letter was given to us, Your Lordship. Page number 70, Your Lordship will see. That is dated January 2021, Your Lordship will see that the final bill has been required and the documents are given. Subsequently, immediately we replied, Your Lordship will see 9/2/2021, next, page number 71. We replied that we have noticed that certain documents are not there and we have given a checklist of the documents that has not been produced to us.
And then
Subsequently, again in the year 2023, the department gave a copy paste of the previous letter wherein we apprised them that it's not something that we have not written that which documents we required. We have very specifically given as a checklist that these are the documents that are.
Who is the chief engineer of the Department of Urban Development and Housing?
Lordship?
Who is the chief engineer?
Yeah. Lordship.
You are not sure.
I'm not sure, Lordship.
Let him remain present in the court.
Yes. Next.
Day after tomorrow at 10:30.
Yes, my lord.
Heard Mr. Mao, learned counsel for the petition.
Chief Engineer, Urban Development, Lordship.
Yes.
But Your Lordship, from our side, Your Lordship, we have done our part, Your Lordship. Even
What
he has
part you have
communicated.
done for which they could not release the bill of the petitioner?
Your lordship may please to see if see the completion dates had been taken over also taken in 2015, my lord.
Position.
Yes, my lord. The Urban has written to the principal JNB at page 28. It letter also clearly shows that the handing taking over that page 28, my lord. 27 and 28, my lord. 6 July 2015. 48 bedded girls dormitory.
Ms. Basar for the respondent number
1 and 2, Your Lordship.
1 and 2, and Ms. Jenny for respondent number.
Your Lordship, there is the NBS was not made a party which subsequently was made, and therefore I would be representing Your Lordship 3 and 6, Your Lordship.
3 and 6.
6, Lordship.
3 and 6. Then this you are representing 4 and 5 also, Madam Basar?
4 and 5, Your Lordship.
Yes.
Department. Yes, 4 and 5, yes. Urban Department.
During the course of deliberation, Mr. Mao, learned counsel for the petitioner, has drawn attention of this court to page number 27, which is a letter dated 13th of October 2015. And on the basis of the said letter, he submits that the petitioner has completed the project in all respects. In all respect, and despite completion of the project in the year 2015, the pending bill of the petitioner amounting rupees.
My lord, 15, 1 minute, my lord. 15 lakhs. My lord, 15 lakhs, 63,000.
15 lakhs 63,000 has not yet been paid by the respondent authorities. Ms. Jenny, learned counsel for the respondent number so and so submits that due to non-receipt of some documents which are required from the Department of Urban Development and Housing, the pending bill of the petitioner could not be paid.
Your Lordship, small submission, Your Lordship. Till date, we have released 1,21,09,330 rupees.
No, the remaining amount.
Yes.
Remaining amount of bill amounting rupees. Ms. Basar, however, submits that they have submitted all the documents.
Lordship.
All the documents.
In the recent letter, Your Lordship, I'm not aware whether what action they have taken, Your Lordship, in respect of the recent letter that we have received, Your Lordship, from the NBS, where they are asking for documents again, Your Lordship.
However, from the letter dated 7/4/2025 of the Assistant Engineer of Navodaya Vidyalaya Samiti, Ministry of Education and Government of India, addressed to the Chief Engineer indicates that some of the discrepancies are yet to be resolved. Some of the discrepancy in respect of the date of completion is yet to be resolved. And also in the handing and taking over of the work, above mentioned work, the completion date has been mentioned as stated 23/3/2017, where the signature of NBS, RO Shillong Principal and DUDH are not available.
Are available. Look at it. Patient date like this.
So whether page number 27 will serve the purpose, this handover document?
7.
Yes, 7.
Lordship, let me take the instruction.
If we go by this letter, there are two dates.
Yes.
One is 8/7/2015, and the other date is 23/3/2017. So whether this discrepancy will stand in the way of releasing the final bill, because it is not in dispute that he has completed the work.
Yes,
Yes,
Lordship,
yes, that's why.
There's no question of.
Because
So how this discrepancy of date will matter?
there are 3 discrepancies of that because
Your Lordship may see page 31 also. There's Navoday's document, my lord.
29 also.
It also shows the completion in 2015.
29 also, Your Lordship.
31. 31, serial number 3. Page 31, serial number 3. The main such and such The project was completed on 8 October 2015.
So then let this assistant engineer of this Navodaya Vidyalaya Samiti also ask to remain present in the
Yes,
court.
I'll just show your lordship, page number 31, learned counsel has shown.
Hmm.
Your lordship will see at page number 30.
Hmm.
30 is part of annexure 429, page number 29.
Hmm.
Ending taking is 23/3/2017.
Hmm.
Then page number 28, ending taking is 6th of July 2015.
Hmm.
So these are, your lordship is well aware that Navodaya comes under the aid of the Union of India, your lordship. Now, when we disburse the amount, the record has to be proper. Only that's why I was submitting, your lordship. Only that discrepancies was to be answered by the department.
Hmm.
Because the documents, because these are all the documents even in our record, and these documents are not corroborating with each other. At least certain all the documents has to
Completion of the work and handing over and taking of the same are two different things.
Yes.
Two different things.
Here they are not
So,
asking for
where-
any
where is
documents,
the-
only discrepancies, your lordship.
Yes,
They have raised the issues.
Has to be explained. That's all. Otherwise, already stated, your lordship, we don't have any issues to disburse the amount, your lordship.
Lordship, let me take the instruction in this, in regard to this letter, your lordship, because we have filed the affidavit before receiving this letter, your lordship. On 3rd, we have filed and we have received this letter on 7th, your lordship.
If I may just suggest, your lordship, on day after tomorrow, we'll take instruction them
Okay,
as well
okay.
as.
Yes, are not available. Not available. However, from the annexer, from the annexer number 3, this page number 27 is what is the annexer number, Mr.
Mallet,
Mao?
page 27 number, Mallet, annexure is Mallet, starting from 3. Yes, Mallet.
From the annexer number 3, it appears that the work has been completed in the year 2015 and handing over and taking over of the building was done on 22nd of March 2017. 2017. So in that view of the matter, the question of withholding the bill of the petitioner seems to be not justified. Accordingly, it is provided that the learned standing counsel for the respondent authorities shall receive necessary instruction in respect of page number 28 and 29 and apprise this court on Friday.
29 and 31 also, Mallet. 31 also is, it shows the completion, Mallet.
Okay, 31. Apprise this court on Friday, March 20. March 20. Recess shall list the matter on Friday.
For matter can be listed for admission hearing, Mallet, and it can be disposed of, Mallet, on that
And
day.
recess shall list the matter for admission hearing on that day. See, madam, you please inform them that we will direct to pay 18% interest from the date of completion.
Yes, Mallet.
Lordship, I'll surely intimate that, but then as your lordship, I have seen that even our process of communication was.
No. It seems to be unjustified in view of the documents furnished along with this petition. Handing over document is there, and date of completion and handing over are two different things. They may not in the same date
Yes. Malad, I am extremely sorry. Kindly allow me to make a mention on behalf of Mr. Tajagaram.
Which matter?
One WPC matter, Malad. WPC number 352 AP 2025, connected by 247 of 2025.
Not listed today.
Not listed in.
Okay.
Malad, just both the parties, the respondent and the petitioners, they have come to a settlement. And then this has to be disposed of with a small direction to the Deputy Commissioner to consider the claim of the parties only for tomorrow, Milord. Kindly listed.
Tomorrow.
Tomorrow. Only just.
Tomorrow. DB is there. After DB.
After DB, Milord, fine.
Second half.
Second half, that is fine. This will be listed along with 247.
Give the number to the.
Yes, I just. It will come automatically. It's connected matter.
Item number 19 to 21.
My petitioner is not here, my lord. But this matter has become infructuous, my lord.
Infructuous?
Yes, my lord.
How?
Because my election is, this is regarding my lord, GPM, my lord. Gram Panchayat member, my lord.
Okay.
Election has already been done, my lord.
Election done?
Yes, my lord. It's completed, my lord.
None appears for the petitioner on call. However, Ms. Wangmo, learned government advocate for the state respondent present. Mr. Wangmo submits that this matter become infructuous as Gram Panchayat election has already been conducted.
Yes, sir, completed.
Conducted in the month of?
In last year, my lord.
Last year?
Yes, my lord.
In the last year. Last year. And as such, a price for closing the matter. Further, it appears that on 19/6/2025 and 30/10/2025, the petitioner remain absent, and today also petitioner remain unrepresented. In view of above, and also in view of the fact that the matter became infructuous, this writ petition stands closed.
Yes, ma'am. Obliged,
Closed, and also for non-prosecution.
Item number 25.
My Lordship.
Yes.
Lordship, I am for the petitioner appearing on behalf of Learned Counsel K. Taja, Lordship. Lordship, as per the instruction of my client, that the petitioner is not willing to pursue the matter further. Therefore, I may be allowed to withdraw this writ petition.
You want to withdraw this?
Yes.
Why?
The petitioner is not willing to
pursue this matter.
yes.
Heard Mr.
K. Ado.
Learned counsel for the petitioner, and also heard Ms. Wangmo, learned government advocate for the respondent. The learned counsel for the petitioner submits that the petitioner is not willing to pursue this matter, and as such, he is willing to, he submits that he may be allowed to withdraw this petition. Accordingly, taking note of the submission of learned counsel for the petitioner, this WPC number so stands dispose of on withdrawal.
Yes.
Liberty not required.
Obliged.
Item number 26.
This is also a panchayat matter, Your Lordship.
None appears for the petitioner on call. However, Ms. Arbasar, learned government advocate for the state respondent present. Unless the matter after a week, in the event of subsequent non-representation of the petitioner, appropriate order shall follow. Next.
Obliged, Your Lordship.
Item number 27.
Same order.
Item number 30.
Lordship, here, service report on report upon private respondent are still awaited, Lordship.
Yes,
Service report upon private respondent are still awaited, Lordship.
awaited.
Yes, Lordship.
You want to take press, sister?
No, Lordship, we will wait for that.
Wait.
Yes, Lordship.
Okay. Third miss.
Waigao, Lordship.
Why?
Waigao.
Why? Wasim Gao.
No, Yasmin Gao, Lordship.
Yasmin Gao.
Yes, Lordship.
Yasmin Gao, learned counsel for the petitioner, and also hard miss Basar, learned government advocate for the state respondent. The learned counsel for the petitioner submits that service report in respect of private respondents.
Yes, Lordship.
Number
Private respondent 7 to 15, I think, Lordship.
7 to
15, Lordship. Or Lordship 7 to 14, Lordship.
7 to 44.
1-4.
1-4. 7 to 14 is still awaited. Still awaited. Recessal list the matter after 2 weeks.
Yes, Lord.
Awaiting service report upon 7 to 14. Yes.
Item number 32.
Obliged. Sir, may
My lord, this is a land acquisition matter. My lord, I have private land located at Tamachungchung in Upper Subansiri district. My land was occupied by Assam Raipur in the year 1968, my lord. And it was handed over to ITBP in the year 2004. Thereafter, ITBP wanted to acquisition my land, measuring an area of 19 acres. In this regard, I have given NOC that 19 acres of land may be acquisition by the ITBP on the ground that possession shall be given to the ITBP after receiving compensation. No objection certificate is in page number 24, my lord. Yes, I will read out some contents. No, by witness present that I, Sri Albat Mura, son of late Nyamin Mura, village Rao, Anna Limiking Circle, Upper Subansiri district, landowner of land at TCC, do hereby affirm and I am willing to hand over a plot of land measuring 7,991.75 square meters or 19.76569 acres or 7.9918 acres to ITBP after receipt of compensation at present approved rate of the government under our right to fair compensation and transparency in land acquisition, rehabilitation, resettlement act 2013, my lord. This is NOC I have given for 19 acres. And after that, notification was issued, my lord. It is in at page number 26 for acquisitioning of my land. There was no objection against this notification. Thereafter, my lord, at page number 30, compensation was prepared. Page number 30, my lord. Compensation was prepared for 4 crore 86 lakhs to 2,987. And this was approved by the Director General of ITBP, the Government of India, Ministry of Home Affairs, my lord. It was approved for compensation amount of 4 crore 86 lakhs 2,987, my lord, at page number 31, my lord. After acquisitioning of the land and even after approval of the compensation amount, I was not paid, my lord. It was approved, compensation was approved in
By the
2000.
Government?
No, Ministry of Home Affairs, my lord.
Where is the approval?
Page number 31, my lord.
31. Okay.
It was approved by under secretary.
Now they are in possession of the land.
Yes, my lord. Since 2004.
2004.
But compensation has not been paid.
So this is the compensation amount.
Yes, my lord.
6 crore, 21 lakhs.
No, the 4 crore, my lord. 4 crore 86 lakhs.
No. Oh, what is this then?
Which one?
This page number 31.
31, yes, my lord. Amount sanction. It is in the last column, my lord.
Right. Right.
4 crore 86 lakhs 2,987, my lord.
The third one.
Third one.
6 crore 21 lakhs.
No, this is for two area.
Okay. This is not belonging to you. Second area is not belonging to you.
Yes, second one is not belong to me.
Okay. Yes, Mr. Kato,
My lord.
why the amount has not been paid?
No, my lord, in fact, this particular case is, my lord, allotment has been given in respect of my lord, ITBP, my lord.
Where? You have filed affidavit?
Yes, my lord.
My lord, my prayer is very simple. Either you pay compensation or you vacate the land and pay me the lease rent after vacating the land. Either of the two. I'm ready to accept the compensation if they pay me. But if they don't pay me, they should vacate the land. Either of the two, my lord.
No, my lord, as per the affidavit, my lord, as of now, my lord, it has not been properly demarcated, my lord.
Properly?
Demarcated, my lord. Area is also not measured. On one or two occasions, my lord, we have written a letter to the my lord, deputy commissioner to carry out the verification process. My lord, they are saying that for which the one IA was filed for perjury and my lord, perjury while filing my lord, the affidavit in oppositions by the ITBP, my lord. But we are not saying that we are not willing to pay any malad compensation amount. We are ready, malad. However, malad, the actual malad, the area has to be ascertained first.
No, how this compensation was assessed then?
Malad, by carrying out the measurement, malad. So therefore, at this stage, malad, may I pray that malad, this matter may be disposed of with the directions to the deputy commissioners to carry out the exact malad, the area under the position of the.
Where is the question of directing him to verify the area again?
No. Lordship, in our para 8, we have said that we have already done
Demarcation done.
demarcation survey of the land.
My lord, page number 22.
76.
Page number 22.
But then, in the meantime, they
32 of your petition.
Yes, 22, my 2.
They have written a letter to us saying that they need only 4 acres of the land.
Yes, madam. Moreover,
Only 4 acres.
madam, ministry is madam, for the BOP, madam, border outpost, only 4 acres of land is required, madam. We cannot, madam, acquire more than that, madam. Now, madam, as per their contentions, madam, we are, madam, in possession of more than that area, madam.
As per?
As per their, madam, statement, as per their claims, we are under possession of more than 4 acres, madam. Whereas, we have been only authorized to occupied for the area measuring 4 acres only, madam. For border outpost, madam, ministry has given the strict madam, the instruction for acquisition of land only to the extent 4 acres of land, madam. Not only in this pocket of area, madam.
All
in everywhere, my lord.
everywhere.
So therefore,
No,
well,
whether you have paid the amount for that 4 acre.
4 acres we are ready to pay, my lord.
My lord, let me clarify. First, let us see whether demarcation has been made or not. Page number 22, my lord.
Yes.
This is a letter written by Commandant 10 BNITBP Police
Mm.
to the Deputy Commissioner.
Mm.
Let's see second para of the page number 22, my lord. There was a long pending issue of redemarcation of aforementioned land for which ITBP had been requesting since long for press demarcation so as to initiate the process of acquisition of land. Now it starts the main thing. The unit is so grateful for your cooperation and timely action taken in this regarding, as the demarcation has been completed. But next course of action regarding notification is still pending, which needs to be expedited by the concerned department. Demarcation already made. Even notification was issued. 2 notifications are there, my lord, for acquisitioning. My lord, kindly see page number 28. This is notification for 19 acres, my lord. And for 19 acres, this notification was issued. Thereafter, for 19 acres,
My lord, we
compensation was prepared, my lord.
We don't require 19 acres, my lord. Only we
Let me complete, please. For 19 acres, this compensation
I think,
assessment has already prepared, my lord. And after this was submitted for approval, it was approved and fund has been sanctioned for 19 acres. Now thereafter, after long gap of time, they have again prepared another compensation for only 4 acres. Now I am saying I have given NOC for 19 acres. Now I am not going to give for 4 acres. Again, they have prepared another document. Of course, it is not available now. Excluding multiplied by 2 to reduce the amount. So some kind of tactics they are always applying against me. I am paid up with them. So my simple prayer is either you vacate it if you don't require my land, or pay me compensation as approved. That much, my lord.
My lord, that cannot be, as because, my lord, firstly, my lord, this piece of land has been taken from the ITBP, my lord. Initially, my lord.
No, from Assam Rifle.
And from Assam Rifle. And my lord, during the, my lord, the handing and taking over, my lord, if area is, my lord, area is mentioned, my lord, more than that, my lord. Whereas, my lord, without going into that, my lord, sanction has been admittedly granted. Is not only for this, my lord, the pockets of land, my lord. The granting was done for all pockets of land, my lord. Thereafter, my lord, we came to know later on that area is more than that, my lord. Whereas the ministry's direction is only for the 4 acres of land, not 19, my lord. Somewhere it is 19, somewhere it is my lord, more than 11 acres of land, my lord. But however, my lord, only we need, my lord, the 4 acres of land, my lord. So therefore, my lord, if lordship see the, my lord, the measurement, even for the notification which has not been taken in effect, if, my lord, it is in my lord, affidavit in reply, sorry, affidavit in opposition, my lord, annexure 5, page number 17. My lord, somewhere it is 146 crore, my lord, 46 crore. Somewhere it is, my lord, 186 crore, 86 acres of land. My lord, it is not properly mentioned, my lord. They are mentioned. Our position is 100 if lordship perused. Firstly, may I take your lordships to page number 12 of my affidavit, my lord. Affidavit filed by the ITBP, my lord. Page number 12, my lord. I am reading, my lord. Below, my lord, it is written to the Deputy Commissioner by the Commandant. Serial number 1, TCC. It is area under possession. They are mentioning that 187 acres of land, my lord. Much exists, my lord. And other is not, my lord, related, my lord. These all pockets of land, my lord, admittedly, more than 19 crores amount has been sanctioned, my lord. And thereafter, my lord, if lordship see, directly lordship come to page number, my lord, 17.
No,
And-
Mr. Kato,
Yes,
you come with clear instruction as to whether you are going to acquire the entire plot of land or only 4 acre of land.
My lord. My lord, as per the, well, I admittedly, my lord, I'll take the proper instruction. I'll come with the proper instruction. However, my lord, as of now, as per this affidavit, my lord, only 4 acres of land is authorized to, my lord, acquire.
Now the question is whether he is agreeable to the same or not.
No.
My lord, the agreement
Earlier,
is-
they have proposed to acquire 19 acres. And for that, PAN has been already sanctioned, my lord. They are not paying. And in fact, I have 187 acres. Out of that, only 19 acres I'm giving. If they require more, I'm ready to give. But not that after PAN has been sanctioned, they will reduce the area of land just to delay the process.
No, my lord, that cannot be. They cannot, my lord, force us to acquire more than that, or
No,
they cannot, my lord, even, my lord, insisting for the, my lord, the payment of the, my lord,
But
compensation.
I am saying, if
Well,
they
the-
don't require my land, it may be vacated.
No, my the question of vacating is not arises because this has been, my lord, already taken from the Assam Rifle, as I have already.
They are
pointed
taking
out.
advantage of their position, my lord. They are in position, they are using the
Time
land.
and again, we are saying,
Say-
sir, let me complete. Your part is over.
One by one.
Yes,
Yes.
my lord.
Sir, my lord, as per the affidavit filed by the ITBP, it is very much clear that for the border outpost, my lord, for this ITBP, as per the ministry's guideline, my lord, we are ready to acquire 4 acres of land only, my lord. And they are saying that in some way, my lord, we are in position of the, my lord, area 187 acres of land. And somewhere, my lord, it is more than that, my lord. So therefore, on the last occasion, my lord, I insisting for the, my lord, the original handing and taking over, which has been taken from the, my lord, Dadin Assam Rifle, my lord. This ITBP was inducted in the state of Arunachal Pradesh in the year 2005, my lord. And while the taking over the land from Dadin Assam Rifle, the area was even more than that, my lord. Even we do not know, my lord, how much area of lands are in our position, my lord. But only authorized to acquire is, my lord, only for the purpose of, my lord, this ITBP BOP, my lord, border the outpost. It is only, my lord, as per the ministry's guideline, my lord, time and again, I'm using
No,
this.
that's all right. But whether you have paid for 4 acre of land.
No, admittedly not yet paid. Not paid, my lord.
So, Mr. Koyang,
Yes, my lord.
you obtain instruction from your client whether he is agreeable to this 4 acre of land.
No, my lord, I have already discussed.
Uh.
He is saying, actually, he has gone to even Delhi to request the authority to pay me the compensation. He has done lot of things. After doing all those things, now he is fed up. He is having vast area of land. If they require more area of land, he is ready to give.
No, that's all right. But if the requiring authority requires only 4 acre of land, you cannot force them also.
My lord, they are changing their stand. Earlier, they needed 19 acres and notification has also been published. There was no objection. Even they have sanctioned fund for 19 acres. If they don't require that much area, they could have give objection earlier. Just to delay the payment, they are doing all these things, my lord.
My lord, just for a moment, my lord.
So
may I
my
take your
prayer is
lordship's
very
view?
plain, my lord. Either you vacate the land if you don't want to pay me compensation, or you pay me compensation as approved. I'm not saying more than that. As approved, already approved.
No, Mr. Kato, is it correct that earlier you have required the 19 acres of land?
My lord, admittedly, there was so many correspondence. My lord, finally, when it came to the notice of the ministry, my lord, as I have pointed out,
No, you see how the fund was sanctioned then.
Yes,
for altogether, my lord, 5 pockets of land, 4 pockets of land, my lord.
No, specifically for TCC.
My lord, may I take your lordships to my annexure 15, my lord? Just annexure 15, my lord. This is the clear position, my lord. Latest position of 2023 letter, my lord. It is written to the Deputy Commissioner and Upper Subansiri District, my lord. Accusation of land for establishment of BOP at Tamata Chung, my lord, present area, my lord. Annexure 15, my lord.
Annexure 15. Yes.
Letter dated, my lord, 14 June 2023, my lord.
Annexure
15, my lord.
Annexure.
Sorry, I'm sorry, my lord. 25, my lord. I'm sorry, my lord. Annexure 25 of my affidavit, my lord. It is later dated, my lord, 14 June 2023, my lord. Addressed to the Deputy Commissioner, Upper Subansiri District, Dapurijo, AP, my lord. My lord, subject is also clearly mentioned, acquisition of land for establishment of BOP at so and so area, my lord. Sir, kindly refer to this office letter of event number dated 15 March 2023 under reference. I am directed to requested you to initiate proposal for issue of land acquisition notifications for acquisition of 4 acres BOP land at Tachung Tama Chung TCC. In this regard, the Commandant ITBP, 10th ITBP Police, ITBP Police, they came in by letter number so and so, that is so and so, copy and close. For necessary, requested for 2 necessary directions for a joint survey of the land. We are only insisting for this much of area, this is the latest letter. It is therefore requested to carry out the joint survey of 4 acres BOP land at Tama Chung Chung and to initiate the proposal afresh for issue of land acquisition notifications for acquisitions of the said land at TCC as requested, madam. This is the latest, madam, letter issued to the Deputy Commissioner for acquisition of only 4 acres of land for BOP, madam. And time and again, we are, madam, requesting the Deputy Commissioners to carry out the joint verification report, or joint verification, madam. And it is also not known how much of areas are in our position, madam. If once it is carried out, madam, everything will be clear, madam. Therefore, madam,
Verification as submitted by Madam has already completed.
no, madam, that was one occasion. It was not properly done, madam. It was not properly done, and somewhere it is mentioned wrong figure. Area is under so and so, madam. Acres of land is our in position. Madam, only for the purpose of madam, without madam, the purpose will serve once this verification
Now,
for.
Mr. Kato, now the problem is that he is not willing to give 4 acres of land.
My lord.
Then what to do?
Yes, my lord, that is another aspect, my lord, that I'll definitely convey to the, my lord, the ITBP. My lord, since we are under the position, we have already taken the land from the Daden Assam Rifle, my lord. It is our under position, my lord. And one point of time, my lord, they never raised this issue before, even when the position was in with the Assam Rifle, my lord. All of a sudden, now they are raising this issue. Earlier, my lord, it was under the position of the Ministry of Defense, my lord. Now it is Ministry of Home Affairs, my lord. And this during 1962 to 2005, they never raised any objection, my lord.
No, maybe.
However, my lord,
They
difficulty
are
is,
not entitled to raise the issue now
my lord, admittedly after.
because it is their land.
True, my lord. But my lord, here the land systems in the Arunachal Pradesh is quite different. So therefore, my lord, we are also agreed to that extent that yes, the whatever we acquire for the purpose of defense, we are ready to pay for that only, my lord. Not more than that, my lord. And for the defense purpose, it is required, my lord. It is border area, my lord. It is located in border area, my lord. And another question is giving of the for the national interest, my lord, their willingness, non-willingness will not serve, my lord. It's because this is for completely for the border, my lord.
Maybe.
However, my lord,
case,
this, even if such is the situation, my lord, this has to be negotiated with the deputy commissioner, my lord. For country security, my lord, this ITBP is required to be posted there, my lord.
No, there is no doubt about it, but the question is, in the national interest, you cannot acquire his land without paying any compensation.
Exactly, my lord. We are not denying, my lord. We are ready to pay for this particular area 4 acres of land, my lord. Only to that extent, my lord. That part, my lord, in affidavit, my lord, we have categorically mentioned, and your lordship has already seen the letter, last letter, my lord, addressed to the deputy commissioner. Please carry out, my lord, the verification for 4 acres of land, and we are even ready to pay, my lord, that part only. Even without going into the other, my lord, the procedures, my lord. Acquisition is also not required, my lord. We are ready to pay, funds are available, my lord. But just only for the purpose of this 4 acres of land, we are ready to pay, my lord. Even other procedure is also not required, as because it is very much clear that the petitioner is the owner, my lord. That part we are not disputing. Only disputing part is.
Then, if you are occupying more than that 4-acre land, then
My lord, admittedly, that has to be vacated, my lord.
that has to be
Vacated, my lord.
vacated. Yes, Mr. Koyang.
My lord, the page number 31. Please, page number 31. And
Of your affidavit, of your petition.
My lord.
Number 31.
Fourth column, my lord. Particulars. In particular, it is acquisition of private land for TCC ITBP BOP. Then next column, my lord, land in acres, 19.776569 acres. The amount sanctioned is 4 crore 86 lakhs 2,987. So there is a clear that sanction has been made for 19 acres, my lord. At the time of sanctioning this fund, there was no objection, there are no issue at all. But they have changed their stand. That I don't like. They have changed their stand.
No, maybe you also take note of another fact that you cannot compel them to acquire entire 19 acres of land.
No, the fund has been sanctioned for that, my lord.
No, maybe even then.
Then another option is they should vacate my land. They should vacate land, and lease rent may be paid for the use of their land, my land, my lord. That much. Order may be passed, my lord. Either you vacate or pay compensation. In case land is vacated, lease rent may be paid as per approved rate of the government. That much, my lord. They have option either to pay or to vacate. They have option.
No, Mr. Koyang, you obtain instruction from the petitioner that whether he is agreeable to leave this 4 acre of land as required by them.
My lord, I have discussed several times. Several times.
Then, my lord, in that case, my lord, for the ejectment, my lord, for vacation, my lord, it has to be filed before the civil court, my lord.
That is why they want to gain time only.
If such is the, my lord, stand of the petitioner, if such is the stand of the
This
petitioner,
is
my lord.
2021 case, my lord.
My lord,
Pan
civil
has
suit
been
has to be
sanctioned-
filed, my lord.
Pan has been sanctioned in the year 2021. This is 2026, my lord.
No, maybe fund has, though fund has been sanctioned, it has not been released.
Exactly, my lord.
If subsequently the
It is-
government has decided to acquire only 4 acre of land, then you cannot.
My lord, I don't think
19 acre of land.
my lord, I don't think that superior authority is directed for acquisition of 4 acres only. There is no such document.
No. Without any instruction or authority, they cannot write that letter, no?
My lord, there is no such.
They say letter
document.
dated.
All the letters are in the commandant level, my lord.
14 June 2023.
That is also written by
No,
commandant.
what commandant has any interest here?
I don't know, my lord.
And
Well, they are keep on transferring for
Sometime what happened, my
after
lord?
2 years, my lord. Every after 2
Because
years,
of
my lord,
delay,
this
corruption
officer
starts. Suppose I'm entitled to get certain amount of money. The payment has been delayed. I will be compelled to give them something to get the payment. So these things are happening in our country.
Kato, who filed this affidavit?
my lord, on behalf of my lord, respondent number 1, 2, and 3, my lord, which include my lord, even ministry, my lord, Union of India, my lord, through the Secretary, Ministry of Home Affairs. Respondent number 1, Union of India, Ministry of Home Affairs, represented by the Home Secretary, my lord. Second is DGP, DG, Director
This
General.
affidavit in opposition by the respondent number 1, 2, and 3.
Correct, my lord.
He is the DIG.
DIG, my lord. Even Union of India, my lord. But however, my lord, the affidavit who shown is my lord, the serving as Director General, my lord. Director General, Station Headquarters, Likabali, ITBP, my lord.
My lord, let the matter be disposed of. Let the matter be disposed of, my lord.
No, without resolving the matter, how can we dispose of this?
Then, my lord, it is to be petitioners who.
You have to approach this court after some days by filing another petition.
No, in case if a specific time is given either for payment or vacation of the land. If
No, Mr. Koyang, you see, we have to see the national interest also.
my lord, I am giving land.
That we cannot readily pass that order.
My lord, this is not the case that I will not give the land.
No, that's all right. But the
Dispute is
area
regarding
that also cannot be acceded to.
dispute is regarding area of land, my lord. I am ready to give. If they want more area of land, still I am ready to give.
Mr. Kato,
My lord.
this affidavit is filed by DIG,
Correct, my lord.
not by the Home Secretary.
My lord, Home Secretary is my lord, is above the my lord, is in representing the Union of India, my lord. Therefore, my lord, he authorized.
Maybe let the affidavit filed by Home
My lord. My lord.
Secretary then will
Yes, my
see
lord.
from the highest authority.
Yes, my lord.
Koyang,
My lord.
let the affidavit be filed by the Secretary of Home Ministry, Home Secretary.
Home Secretary, my lord. Yes, my lord. We are ready to file, my lord. We'll file affidavit to that extent, my lord, clarifying the aspect, my lord.
And in
Every
the
aspect.
meantime, you also obtain instruction from your client whether he is agreeable to give 4 acres of land.
My lord, I have discussed several occasions, in several
Now,
occasions.
maybe you also let him know that this is a national interest project for security of him also.
Well, that area has been fully developed by this force and the ITBP, my lord. The rest portion is also belongs to him. That is never developed. It is still in forest land. Unused area of the the petitioner is my lord.
He may not agree because even if he agrees, long process is there. Publication of notification, then demarcation, all these things, and another NOC has to be issued. Long process is there.
In that case, in the event of being agreed, then we can ask them to complete the entire process within a definite time frame.
Correct, ma'am. Yes, ma'am.
Say about 2 months or 3 months.
In that case, my lord, view of the court may be reflected, not my submission. Order may be passed for directing to pay compensation for 4 acres. But as per 2013 Act. Solatium, multiplication, everything.
Definitely, my lord, that will be there.
They have
Definitely, my lord, that will be there.
my lord, they have prepared for 19 acres without multiplication. I have not brought that paper. It is with the deputy commissioner, my lord. So seeing these things, they are always applying some kind of tactics either to delay or to reduce the amount. I should get the proper compensation as entitled under law. So I'm fed up with the ITBP dealing with them.
Okay, that's all right. Let us fix a very short date. You obtain instruction from him.
No.
And in the meantime, he also file,
No,
Home Secretary also file an affidavit.
My lord.
He will not agree, my lord. Only if your lordship passes order today.
Mr. Koyang, you see, let him understand the gravity of the matter.
My lord.
On one side, the national security is involved.
My lord,
the other side is personal interest.
No. When we obstruct or we refuse to give land, then we are disturbing the national interest. But we are ready to give whatever they wanted.
No, that's all right, but you cannot
My
force
lord,
them also.
my lord, one thing.
Which is not required for them.
My lord, I don't know.
My lord,
My friend
I'm
is.
not saying everything, but as told by him, he has taken lots of trouble, my lord. He has appeared before ITBP officer several times. And he has even went to Delhi. He could not get anything. So he is fed up with dealing with the ITBP, my lord. I have also seen they are applying some kind of tactics either to reduce the amount or to delay the payment. I have seen it on record. So he is really fed up with ITBP. He wants, if the land is vacated.
Even then, you convey to him that this is the view of the court.
My lord, may pass such order, my lord, whether ITBP is required this much of area or not. And to that effect, my lord, the Ministry of Home Affairs, Home Secretary, my lord, is directed to file affidavit to that extent only how much of area is required by the ITBP, my lord.
Since, my lord, it is very clear that 4 acres of land they require. Even if they file affidavit, same thing will happen. So my submission is, my lord.
No, Mr. Koyang, you have raised doubt that this is being done by this DIG. So therefore, let the affidavit come from the Home Commissioner, no, Home Secretary.
Home Secretary.
In that event, there shall not be any doubt in your mind.
My lord, if your lordship passes order, he may accept it. So my prayer is to pass an order to accept 4 acres of land and payment be made within such and such period. I think that will serve the purpose. But my submission should not be repeated because I have discussed many times.
No. I will pass that order, but you obtain instruction from him.
My lord, I'm saying, even if I talk to him just now, he will refuse. Because lots of trouble he has done. Even he told me, I have spent many money. He went to Delhi several times. Even if payment is made, he is saying, I may not get benefit.
Maladi is not required to go to Delhi even.
If
Office is located here.
If order is passed, no problem.
Malad, just for information, Malad, it is not only the case where Malad, this such type of situation arise, Malad. In every cases where Malad, the land was taken by the ITBP from the then Assam Rifle, Malad. Everywhere it happens, Malad. Lordship, in that one case also, Lordship has passed an order.
Then in that case, Mr. Koyang, if that is your view, then we can pass order.
Yes, madam.
You acquire 4 acres of land
as per
under the Lara Act.
Yes, madam.
And give adequate compensation to him.
Malad.
And the process shall be completed within a period of 2 months.
2 months, madam.
From today.
Yes, madam.
Yes, madam.
In my affidavit also, we have said that after getting that letter, hence the process of submission of the same was under process. Meanwhile, the petitioner had filed this petition, so everything is stopped.
In that case, he may accept it under compelling situation. Otherwise, he is not interested.
Okay. Then within a period of 2 months, entire
Process can be
process
completed.
has to be completed.
And regarding compensation, my lord, the compensation amount as per the, my lord, the new act, my lord, as per new act 2013 act, my lord. Yes,
My lord, the specific direction may be given because they have attempted to prepare a compensation without multiplication. It is on the record of the deputy commissioner. So this multiplication be applied.
Whatever is provided under the 2013 Act,
Yes, my lord.
they have to do it.
Yes,
Yes, ma'am.
yes, ma'am.
They have to do it.
Exactly. It will be basically done by the deputy commissioner only, my lord.
Yes.
Okay.
Yes.
Within a period of 2 months.
2 months.
From the date of production of certified copy of this order.
Yes, my lord.
Certified copy of this order of this court shall be produced within a period.
And my lord, one thing, the excess land beyond 4 acres,
Vacate it.
that be vacated and lease rent will be paid as per approved rate, my lord.
Rent.
Yes, for the use of the land, lease rent.
Okay. Okay.
Marat, another in that aspect, Marat, as I pointed out, it was taken from the other Nasab rifle. Then in that case, from
2004
Marat, up to 2005, it is the
under your position.
no, it is the Malat, the Ministry of Defense, Malat. And Malat, from 2005 to till then, Malat, it is our under position. Our position, under our position.
Ministry.
Ministry of Home.
In fact, from 2004 as per record, but I have no objection if
From 2005.
2005
Okay.
because I want to settle the matter.
Okay. Okay. Okay.
Deep level.
We'll pass.
Oblige, my lord.